Is it okay if we address you from here instead of the standing up at the lectern? Does it matter? Okay, thank you.
Should have been more forthcoming. I think the last one we had everybody in a square, but I dropped the ball on this one, so
No.
apologies.
Everybody else is way in the back, so I feel a little isolated, but
If we want to, I mean, at this point, reorganize, if people would be more comfortable sitting in the square, I'm happy to have parties and interveners, just so they don't all have to pop up at the microphone. You don't have a problem with that, do you?
no, of course not.
Right. Whatever it's, I think that might be, make it more convenient for everybody. So we will take a brief pause and then we'll start the formal proceedings.
Hi.
Good morning. All right, I think we have everyone in place and we will officially commence the proceeding, if we may. Good morning, everyone. I'm Commissioner Holly Cheeseman, and I'm joined by my intrepid and independent colleagues, Commissioner James Smith and Commissioner Jan Beecher and Commissioner Everett Smith. We are here today for oral arguments in docket number 251113, remand of the application of Southern Connecticut Gas Company to amend its rate schedules. This will be followed by oral arguments in docket number 251114, remand of the application of the Connecticut Natural Gas Corporation to amend its rate schedules. As a reminder, the evidentiary record has closed. The purpose of today's proceeding is to receive oral argument from any party or intervener concerning the proposed final decision. This is not an opportunity to introduce new evidence, but rather to present arguments with respect to the record that is currently before the authority. I will take appearances, address any administrative matters, and then proceed with argument. Before I take appearances, I will note we do not have a court reporter today. Unfortunately, her car broke down on her way here. The agency was not able to supply a substitute at such short notice. We will be recording and broadcasting on YouTube, and they will make a transcription from that, so that should be available. But I just wanted to point that out to the parties here today. And now I would like to take appearances, and we will then address administrative matters and proceed with arguments. So I will start with the applicants, please.
And Cheryl Kimball from Keegan Rowland on behalf of Connecticut Natural Gas Corporation and Southern Connecticut Gas Company. And with me is David Martin, who is the Vice President and General Counsel of UIL Holdings.
Thank you. Office of Consumer Counsel.
Good morning, Commissioners. Andrew Minikowski for the Office of Consumer Counsel, and I'm joined by Consumer Counsel Claire Coleman.
Good morning. Attorney General.
Good morning, Commissioners. John Wright on behalf of the Attorney General.
Thank you. And Pura Office of Education, Outreach, and Enforcement.
Good morning, Brittany Wyman for EOE, joined by my colleague, Attorney Jamie Spanhake.
Thank you. Are there any other parties or interveners who wish to participate in oral arguments this morning? Seeing none, are there any administrative matters that parties or interveners would like to address?
We did see the correspondence filed by the company on Friday regarding our signature page. We are happy to refile with the signature, and we can do so after the oral arguments.
Thank you. Any further administrative matters? No, and we can address this at the end of this particular docket, but I will be asking parties if they would like to adopt similar answers for argument in the next docket. So we will now hear arguments from parties and interveners. You will also have the opportunity for rebuttal. In accordance with the authority's regulations, the company may have the first whack at this. You could open and close the hearing. So we will invite the company to present their argument first.
Okay, thank you. And I'm glad that you mentioned that there are two dockets because everything I have is one, and then we can adopt later. That's a good idea. Okay, so I just wanted to start off by thanking you for your attention to both dockets. On behalf of the companies, we really appreciate the change in circumstances and the new outlook and the hope of a constructive regulatory environment. So everything that we are going to say today is in that vein. We know that this is a tough one. This is so hard, like to go back and do this over again. I've never seen it be done. It's very difficult to go back and think you're going to tread through all these hundreds of hours that all the parties have spent and try to build everything from the ground up. It's really not even probably possible. The companies are going to have to file a new case. They will be doing that in the near future. We know that everybody is anxious to move on. But the companies are still owed under the order of the court, an answer on these cases. So we do have to go through the issues today. In that regard, from our point of view, it is a little bit unfortunate that the draft decisions are virtually verbatim to the previous final decisions and draft decisions. Excluding the consideration of customer credits, these draft decisions actually reduce rates. So it's a $2 million rate reduction for CNG and a $600,000 rate reduction for SCG, which means it's a worse result than the last time, which was issued under what the court has found to be improper circumstances. The one decision that the draft decisions do include, which we want to give credit to, we appreciate, is the raising the cap on the DIMPs. And that's very important because it's important for gas companies to be able to replace leak-prone main. This is, the state is looking for the companies to replace an accelerated level, and this will help support that. So it is a good decision. But the thing about the DIMP is you have to spend new money in order to get that money back. So getting the cap raised on that, as good as it is, it doesn't help on the base. It doesn't help on the base rate side. It doesn't change what's going on with base rates. And so what we get to is that the draft decisions, you can just run a compare. They're 90% identical verbatim to the prior final decisions. And so from our perspective, that doesn't feel like a new thought process. It doesn't feel like Pura has stepped into the shoes and done everything and thought about all the different angles. But be it as it may, it's a difficult process for everybody. So today we're going to try to focus on just a few issues that have rate-making impacts even beyond for customers and beyond this case. And we just want to try to give it a little more three-dimensional perspective to have you reconsider some of the decisions in the draft. I need to go back in terms of legal principles. We did appeal the original decisions on December 19th, 2020. Sure. And you have to really, because I keep talking. Yeah.
Commissioner Smith has a comment.
Yes.
Just on that point, so a couple things. First, there's form and there's substance.
Right.
And I think that perhaps later Commissioner Beecher might want to get into some substance points, but the form is the form. And I just curious, would you have felt better if we had just taken the old decision, put our new thinking into it, stuck it in AI and come up with different adjectives and adverbs?
No, I don't think I would. And I don't think that's what I'm saying either. I have some concrete examples to go through where there's, oh shoot, I just got this weekend. I don't know how to shut it down. Okay, I'll put it. There's some concrete examples in this order of statements that were made that are unchanged from the original decision. And so when they're unchanged, I have to, it makes you step back and say, what was the thought process here? What was the discussion internally? Because obviously new commissioners have to be guided, by people who have been here and who know the precedents and the different practices.
And Attorney Kimball, I know you were going to cite some specific instances, and I will be very interested to hear them. But as I stated at the beginning, I have intrepid and independent commissioners.
Yes,
At the end of the day, the signatures on the decisions are from these three commissioners who are sitting here, not two commissioners who were accused, not a commissioner who is no longer here. And you can rest assured that none of the decisions that went into this were dictated or determined by people who were here before. That every issue was weighed by this panel, and it was a monumental task. Hundreds of pages, hundreds of hours. Believe me, we would not be sitting here today had we not taken this docket, the accompanying docket, the remand of the court very seriously, and attempted to do within our ability and with expert opinion from all parties to come up with a decision that we thought was just and reasonable. So I look forward to hearing your instances where you think everything was verbatim. But again, is it a good use of our staff time if we are in 100% agreement of items in a decision to say, oh, let's word it differently? But again, I will welcome the opportunity to hear specific instances you have. And obviously, the purpose of today is to listen to people's points of view and arguments as we go forward.
Attorney Kimball, before you were in the middle of a thought, and that actually caught my attention. You said the new commissioners needed to be guided. Is it conceivable that new commissioners might give guidance?
yes, it would be, especially where a new commissioner does have a very good knowledge of the rate-making practices and different policies, 100%.
Okay, and so like, tell me a little bit what's your thought around the word guidance? As you said at the beginning, it's a complicated case, and I believe Commissioner Cheeseman and I, we arrived first, and very early on, spent a good number of hours rewatching hearings and starting to become familiar with this record. So, this has been a long process, but definitely, I think there was frankly an expectation here and an obligation that we know the record. So I just urge a bit of caution in speculation.
Right.
But I do want you to continue your
Okay.
thought.
And I am not discounting any of that. And I frankly knew that this is exactly the reaction that would be provoked if I said these things, because I know how proud this commission is of like coming in and starting new and being balanced and impartial and doing the work. All of that stands. None of that is being discounted. But I think this will be revealed as experience goes forward into the future through other rate cases, without being in the case on a three-dimensional basis, without being able to ask your own questions. The whole thing about a commission, what does the commission do as a fact finder? The commission is weighing the credibility of the witnesses. That's what happens in an administrative hearing. The witnesses come in, they have questions and answers, and you judge the credibility and you explore, you're able to explore. So that's different than watching every hour of a hearing by questions that were asked. The questions that were asked by that bench, by those commissioners, as to what they were interested in and where they wanted to take it. You didn't get the chance to ask your own questions.
We did not, Attorney Kimball, and we were acutely aware of that, and you were acutely aware of that. And one remedy that I'll come back to perhaps a few times is that you had the opportunity to file a new rate case before an entire new panel of 5, but it was your choice to continue to litigate. Is that correct?
Yes, because we also had the right from the court in the meantime to get a fair and impartial answer to the last case in the meantime.
Correct. So that's a trade-off.
So it's not a trade-off, because if we file a new rate case, you're not, that, first of all, takes a while to put together.
Of course.
And second of all, it has to be all litigated over the year. So you're not going to get an answer on that for a while. So there's a few issues that we were hoping to focus on from the last that actually were anomalies, just even in terms of rate-making practice.
I
That
understand.
we were hoping to get looked at in advance of that next case.
Right, and we could be, our commitment was to be time travelers, but the one thing we couldn't do is go back in time and be physically in the three-dimensional room.
Right.
That's what you're saying. But we all knew that at the
Mhm.
onset of this.
Yes.
Okay, thank
I
you.
think, absolutely, I don't disagree. Another aspect is, though, for every one of these issues, there's always a history. There's a history. For every Public Utility Commission, there's practices, there's policies, there's, from everything from how you file something with the commission to what the rate making, how the commission views what a utility should be doing, what the incentives are that the commission wants to set, what the commission thinks is important about an issue, always going to be different. And I think a little bit, I will absolutely agree with everything you're saying. I think a little bit what's happening is it's discounting how pervasive that when a proceeding is conducted by someone that has an end result in mind before you even get started, like how pervasive that might actually be, and just even the way it was conducted.
Okay, were there, was it a panel of 1 or was it a panel of 3?
It was a panel was only signed by 2 commissioners in the end, not 3. It
But
was
2,
signed by 2.
but a majority of,
But the draft decision, it's been admitted now by Pura that the draft decisions were written and prepared by the presiding officer who was self-appointed. So the final decision, if you compare the final decision to the draft decision, they cleaned up some mistakes, but otherwise it was the same as the draft decision, and now it's the same again.
you're talking about the prior case,
Correct.
as you called it, there was a draft and a superseded draft.
Correct.
Does a proposed final decision have any legal meaning in Connecticut?
It didn't, and it doesn't, except that in this case, it was prepared by someone who's now not here. And now it lives on, and not here for a reason, and now it lives on in the current drafts. It's been adopted verbatim. So I hear you. I don't discount it all.
I'm sorry, so your theory is that if we would give direction to the staff, we'd make a policy determination. And in some cases, it's a binary decision. I'll just jump right into it.
Mhm.
ROE versus a disallowance to rate base. Those are 2 choices. It's kind of a binary choice, right? And it looks, the history here looks like the authority considered one, they considered the other, they landed here, they landed there. We look at the new evidence, and you really have no basis to imagine that we relied on a proposed final order because of a prior case. That'd be kind of a waste of time in my perspective.
And I honestly do not think that any of you did that. I'm not suggesting that at all. However, let's take that issue in particular.
Yeah.
There is a whole background on that issue of used to be called underutilized, now Pura calls it unused.
Okay.
A whole background, which we're going to talk about today, that's one of the issues I want to talk about, that it's not just the evidence in this record, which I'm sure was completely reviewed and thought about. It's all the circumstances going back to 2013, which pertain to that legal assessment. And so it is illegal. We'll go through this and we can use this as an example. So it's not just binary. It's not just ROE or unutilized. It's the whole legal surroundings of that issue that if someone is brand new, may not have that context.
Okay, I understand, but we're not, we're talking about a choice in this particular case with these particular facts. These are the two, I would consider them the primary policy options that an authority would have to address this particular issue.
Mhm.
So I just, the fact that we would direct the staff to write up something for us, and they would have an available analysis and use it, I don't see why, I don't see why this indicates a problem. I mean, in other words, the work was done, time was short, we had a lot of work to do.
It doesn't give us any idea into your exact thought process, which is always very thoughtful.
Okay, well, now, are you suggesting we didn't read the order?
Oh, you definitely read it, and I have no doubt about that. But you just said yourself it was prepared by staff.
Not all of it, some of it
is-
we contributed to.
Oh, yes, you did on taking away rate case expense or taking away other things. Yes, we wrote some new stuff and we're appreciative, and that's where we do know there's thought process. But when you're saying that you just utilized a write-up from staff, right there proves my point. The pre-existing things that are embedded, the pre-existing thought process, what if that write-up actually was falling short because it actually it was outcome driven the last time, so it's excluding thought process of 10 things that would have pertained to that decision, but were left out of that decision because it was outcome driven. So now you've come in and you've looked at the evidence, no doubt about that. But now you're adopting the answer that existed before that didn't have the 10 other things that might be considered in that answer legally as to like past precedent.
So, so you're using the term outcome oriented, and that's not, that's not something that, that I would subscribe to.
Agreed.
I mean, but there is policy oriented,
Yes.
and those two could align.
They absolutely could align, but does part of it have, one thing that the utilities are looking for, which is part of a constructive regulatory environment, is consistency. So if we think about, and not having every rate case where the standards changed every rate case. So we look at, for an example, inflation. You can look at every case going back in history, and except for the most recent cases, the inflation adjustment was a rate-making practice. So now it's disallowed here, even though it was allowed in the prior rate decision. So all of these policy choices that are in here are predicated on what came before in the other orders here. And they have to be because you wrote it, unless you changed it, which there was a couple of changes, it's the same thought process. It's the same.
I think we could go round in circles on this for a long time. And I'll
I'll
let
just add one
Commissioner
last,
Beecher and Commissioner Smith
one last thought.
get some last thoughts, and then let's proceed, because I have no doubt other parties and interveners are going to have opinions on this, so.
I'm getting ahead of myself, but you yourself in your exceptions and possibly the motion, I'm not sure, but refer over and over again to correcting the prior order, the remanded order. Doesn't that suggest that we would go through and look for opportunities to correct? And does correct in your mind, we'll come back to this, but is a correction always in your favor?
No, I knew you would ask me that question. I actually thought about this for days. You were definitely going to ask that question. No, it doesn't mean it has to go for the utility. Absolutely not. And no one expected to come out of this with some vastly different outcome than before. The process doesn't yield that change. That'll come in a new rate case, just like you said. However, in the original decisions, every single issue went against the companies. Every single issue still goes against the company, except, okay, DIMP, that got changed, but then two things got taken away that outweigh that change. So we end up in a worse position than we were. And it's so one-sided that the consumer advocates in the room don't even have anything to contest about. No issues are contested by them in their written exceptions. So from our perspective, that doesn't appear like a balanced, an attempt at going back, and the things I'm going to talk to you about today, every single issue is absolutely in a way a judgment call. Every single one. It could absolutely go against or not. I'm going to ask you to think about it in more of a 3D fashion. We'll go through it. I just have four issues. But when it comes out that way and it's identical, I'm just saying to you what it feels like over here, like it's a double down, like it's trying to validate. It's actually trying to validate what Pura did before as correct. And so that's what it feels like out here, because it's the same language with the same outcome, only worse. So I'm happy, let's let everybody chime in, but I would like to go through, I've worked very hard to try to put together some very specific things we can go through. And I don't want you in any way to think that I don't agree with you on everything you're saying of how you approached it, how much time. I think it's an impossible task in a way to recover from what happened, right? It's a little unfair that you're even being asked to do this. And so no one thought this was going to be some great hallelujah outcome. It's not going to be. It was too bad to begin with. But there's a few issues. We'll go through them. I'll stop. We'll go through them and we'll talk about them. And I'll show you what I'm talking about.
I just have two thoughts. One, it's on. Sorry, someone took away my handheld mic. I knew they were going to do that because I talked so much last couple weeks ago. So but it sounds to me like you're suggesting that I'm a rubber stamp.
No,
And we're not a rubber stamp up here. And, you know, I don't give a goddamn what happened in the years before we got here. We're going to look at things and we're going to try and do it right. And you know what? Maybe there were no changes because we thought it was correct. Is that a possibility?
Yes, it is 100% a possibility. So I'm going to take absolutely, and no one is suggesting you're a rubber stamp at all. You of everybody come across as having a whole different outlook on things. You're not, you haven't been immersed in utility baloney all these years. So you're going to look at.
Really ignorant, yes.
I didn't mean that. But you definitely, there's just such appreciation for the new viewpoints. But I think there's a little bit of an underestimation of how embedded some of the outcomes could be. So we'll go through a couple issues and we'll discuss, okay?
Just again, to be clear, there are people in the back of this room I listen to. There are people on this side of the room and that side of the room and that side of the room I listen to. And then when I don't understand something, I listen to these guys. So let's just be clear, that is the process.
Understood. Absolutely understood. Thank you. Should I pause here or do you want me to keep going? I'm happy to let others chime in if,
I think it would be helpful if you make your points and
Okay,
then people
fine.
can chime in as needed if we can proceed that way.
Okay.
Attorney Kimball, are you happy with that?
yes, very happy with that.
And-
Okay,
Consumer Counsel, all right. Thank you.
okay. So I think first what I'd like to do is just as by way of an example of where I want to start with is if we look at page 2 of each decision, there's a paragraph in each decision which is unchanged from the original. And it says, it's talking about whether it's SCG or CNG, it's that they're identical for both companies except for a couple of the years. But it says that, like, for instance, this is for CNG. It says, importantly, the company has not had, it's the second paragraph on page 2. Importantly, the company has not had a fully adjudicated rate case since 2014. Its 2018 rate amendment application was resolved through a settlement agreement. Under the terms of that settlement agreement, the company has continued to earn healthy returns, including several periods of sustained over-earning. As a result, in 2023, the authority directed the company to file a rate amendment. Okay. So sustained over-earning. So this was in the original order. So this conveys the sense of this is the justification for here's why rates are going down. Here's why the companies didn't get what they wanted, because they've been over-earning, sustained over-earning. But if you go back and look, go ahead.
Was that an untrue statement?
Yes.
There
Because-
was not sustained over-earning.
No, because if you go back and look at the records from 2017 till now, Their 1 year CNG over-earned, which was 2022, and 1 year SCG over-earned, which was 2021. Now, Puro makes the utilities report ROEs on a quarterly basis, rolling 12-month basis. So there can be periods in the middle of a year where a gas company can be over-earning because gas companies are seasonal. They realize a lot of revenue in the winter periods and less revenue, less collections in the summer. So even when you're doing a rolling 12-month basis, a gas company's ROE at any given time, except for the end of the fiscal period, is going to go up and down. And if you actually looked at, if the facts were looked at as to whether or not there was sustained over-earning at the end of fiscal periods for these two companies, the answer is no. Another important fact is CNG, when it was over-earning in 2022, which was importantly the test year for these cases, it over-earned by $5.6 million. So its total earnings were $35 million. It over-earned by $5.6 million. Under the settlement agreement, it gave half of that back to customers with carrying costs. So they got back about $4 million. The rate reduction that happened in 2024 was $18 million reduction. So that was 3 times the over-earnings. So I only bring this up that this is one example of one paragraph that was justifying, it was put in here to justify, here's why you should expect these to be rate reductions, or you should expect these to be lower than average increases or whatever, because they sustained over-earning. 1 year, each of the companies, 21 for SCG, 22 for CNG. All other years, 2017 till now, no. There's not sustained over-earning. So this to me is important because this set the stage for a lot of what happened before. Now, I hear you, everything is different now, but this is in the order. So how do I know that you've all signed? So how do I know whether you believe that there's been sustained over-earning?
But how is it relevant one way or the other, whether you had sustained, excuse me, over-earning or not, and whether or not it's in the order? We were looking at your proposed revenue requirement in this case for this test year.
Then why include that paragraph?
Well,
Why is it here?
it's explaining the context of why the cases were initiated, correct?
It states that at the end of the paragraph. It's not factually correct. And the decisions have 100% against the companies. Like 100% of the stuff is going against the companies. There's been a little trimming here and there. I don't want to take away from that. Appreciate that. But so nothing. So this indicates a belief on behalf of the potential people signing that there's been sustained over-earnings, and that's a basis for taking a really tough look and having everything come out against the utility.
But a rate case is perspective.
Mhm.
So again, I mean, did your exceptions lay out your concerns about that paragraph?
No, our exceptions laid out the fact that it was duplicative writing.
Okay.
So now we're here today and you're not happy with the fact that I'm saying we're concerned. And so I am prepared with examples to walk you through where that concern arises.
Well, just to be clear, we absolutely respect your right to raise your concern.
Okay.
And that we're here to hear everyone's concerns. And so we're not, we don't take that personally. But we also want to challenge perhaps some of the thinking that seems to be behind the motion and the exceptions that you presented here. So we're just, again, we're here to have a robust
Sure.
argument. Thank you.
And again, I guess another thing I would just say is,
Can I just?
yes, of course,
sort of
certainly.
connect
So.
all these thoughts thus far.
Yeah.
So just using your previous unused services and mains example. So when I go and I drag out all the evidence and I look at what all the services and mains were and where the pipe was and who put it in and who didn't use it and what all the facts and circumstances are and make a decision on that, what does that have to do with whether there's sustained earnings, which I never actually spend any time having any context.
Yeah,
around it.
awesome question. Awesome question. So let's talk about two things. First of all the way through the order is the word discretion. Pura is exercising its discretion, and there's a lot of judgment in a rate case because things can go either way. And who does the tie go to? Does the tie go to the runner? Does the tie go to the other team? Like, where does it go? And that's, the court has validated that Pura has that discretion and makes those judgments. So it matters what your viewpoint is in terms of the context, because now whenever you use judgment, for instance, to remove an ROE penalty from unused mains and services and to instead disallow the cost, that's a judgment call that you're allowed to make. That's your job as a commissioner, and you can make it. But it might be made differently if you thought that the companies had been sustained over earnings and, they deserve a little bit of a tight rein here. That would be fair, but that would be a context that would come out of this.
Okay, and I understand you're on the outside looking in,
Mhm.
but from where I sit, it never
Okay,
would have come into play. These are
fine.
things.
So let's talk about my second point. I wasn't going to address unused mains and services till the very end, but let's talk about it now since we've raised it. That will take it off the end. Okay, so bottom line, unused mains and services are being disallowed because of this idea that there's no customer attached to the other end at the meter. That's fundamentally why you're disallowing the costs, and you're finding that it's not used and useful because there's not a customer on the other end. So, but the way it works under the law, and the prudence analysis, it's a little more, so bear with me. Gas companies and electric companies have obligations to serve customers, existing customers. Once a customer becomes a customer, you own that customer. You have an obligation to serve that customer through thick and thin. They're not the same when you're a new customer. All new customers have to be served by an electric company, have to be served. Anybody who comes has to be served. On the gas side in New England, there's a different tact because gas customers had options. Electric customers, no option to electricity. Gas customers, they could be oil, they could be propane, they could be electric. So gas companies never had an obligation to serve that new customer. So what typically commissions, all the New England commissions do, is you have to apply an economic test to decide, kind of like the go decision, which is really fundamentally the prudence decision. So is it prudent to take on this new customer or not? And the way that gets determined is by looking at the hurdle rate, which is essentially an internal rate of return equation. And what that says is, what is the cost of adding that customer? And is that cost going to be more than the customer is going to generate as revenues? And if it is, then the customer has to make a contribution. The customer has to pay down the cost of the installation so that the cost of installation is kind of equal to or less than the revenues that customer is going to produce. So gas companies use the hurdle rate. It's almost like a prudence test. It's a go decision. Should I be adding this customer or not? And at the time you do that hurdle rate, there's a customer on the other side, or you're not doing it because it would be zero. You couldn't pass the hurdle rate if there's not a customer.
Okay, if I could jump in. So you've used the term prudence a couple times. So given that the legal framework is different for gas as compared to electric, your prudence test, your managerial internal prudence test is not the same as our test.
Well, I think it is, because if I could just finish where I was headed just quickly, then I love your question. That is not the go decision to add this customer is not the full prudence equation, because of course you have to come in, you have to cost manage that project.
Right, so you're bearing some risk in all of this.
Yes, you have to, you do the go, no go, which says, yes, this customer is going to produce enough revenues, either with a kayak or without, either with a contribution or without a contribution. They're going to produce enough. So yes, they need the economic test to come on. So at the time I make the decision to build that main and service, at the time I make the decision to build it, that customer is there. I've run their equations of their service into my hurdle rate. And I will move forward with putting that means and service into the ground, knowing that with the reasonable expectation that that customer is going to be there. That's the point of prudence. Now, I have to manage the costs of that. I control the costs of that. So as you go along, you have to manage the costs of that. And when you come into the regulator in a rate case with your documentation, you're saying the customer passed the hurdle rate, and I managed the costs so that they stayed in line with what was expected in the hurdle rate. So my customer addition was prudent. And you can get accepted or not accepted by the regulator. Here, all of this is getting found these means and services are getting kicked out, but not because based on a determination that they didn't meet the hurdle rate. All of these customers met the hurdle rate. All of them, we gave the cost documentation. There's no finding that the costs weren't managed. What the finding is the customer's not there. That's an after the fact. That is an after the fact change in circumstance. I just want to finish, sorry. And you're saying, what Pura is saying is, because that customer is not there, the main is not, or service is not utilized, but in fact, it is gasified. It is part of the system. It's got gas in it, live gas. So the fact that the customer is not there, it's being cast here as a used and useful issue when it's not. It's actually a violation of the prudence determination that you're coming back after the fact and saying you lose because the customer didn't show up, which is after the point of the prudence determination.
Okay, so
I'll stop. You go.
thank you very much. So, so inclusion in rate base is a two-part test,
Mhm.
used and useful and prudent. And another way to think about used and useful is it's beneficial. Another way to think about it is that it's revenue producing, right? That it's
That's why it has a hurdle rate, because it's revenue producing, right?
It's got a hurdle rate to inform your decision-making process.
The hurdle rate is applied, it's only applied to new customers. It's not applied when you're doing like reliability additions where you're adding for other reasons. It's only applied when it's new customers revenue producing.
Right, and that might be really useful in a, so to speak, in between rate cases, because you could, even though you're still on hold to include something in rate base, you'd start getting revenue. So that, that at least helps you make that.
The revenues are after the fact though.
Sure, exactly.
Okay.
But realizing that customer and, in other words, meeting the used and useful standard depends on that customer taking service. And so to me, like, that's a pretty clear,
That's not the
manifestation
definition of used and useful. It isn't. If that were true, you'd have to go around the whole system constantly every day. And what if there's a vacant house? What if there's somebody moves out of a house, cuts off their gas service, and that house sits there for 2 years with no owner in it?
there's no rate, they're not a ratepayer either. If they're not, there's no homeowner, there's no ratepayer. So, I mean, and so.
So what does that mean?
Okay, so
Yeah.
the cost, that's a sunk cost issue. So.
No, it's in rate base. You're saying if the customer isn't there, it's not used and useful. So I'm asking, does that mean that if you have a gas service serving a house and the customer's moved away and turned off service and nobody is taking service for 2 years at that location, are we now disallowing that service as not used and useful?
Intriguing idea, but I think here we're talking about including plant and rate base, not auditing the system to see.
It's the same standard. It's the same thing though, because these were at the time, these mains and services were installed. There was a reasonable expectation of the customer on the other side. In fact, they had signed a contract.
Right, I understand.
So there was a reasonable expectation. And so the prudence determination, which is made at the point that you make the investment, there was a customer on the other side at that point.
But there
That-
has never actually been a customer.
But but there can't be a customer until the gas is put in, right? So the system is put in and gasified with the expectation that that customer is going to come online and then and that's the prudence determination. I was prudent in putting in that line because I had the expectation at the time I put it in that that customer was coming. And you don't know till afterwards that the customer hasn't showed up. But that doesn't make that used and useful, because if it's gasified, the system, it has been added to the system and is now part of the system. You're confusing, what's happening here is we're confusing used and useful with the prudence determination. And this is an after the fact look back on the prudence determination. That's what this is.
Well, we will obviously hear from other parties with regard to this as well, but I thank you for your explanation. Commissioner Smith.
So I think one of the questions here was whether or not there was any enforcement. So you had the customer contracts, that's great. They reneged on you, that's bad. What did the companies do to try to enforce those contracts?
Right. So that's that's a separate issue than used and useful, completely separate issue. So they had contracts with these customers. And in many of these instances, Pura had a bar because of COVID, could not go after these customers. So you couldn't take legal action against these customers. Nothing about that is in the order. Even if you go after the customer, you're never going to be able to force the customer to take service. You might get some money back. You might get some money, which then Pura could quite rightly say, you should be pursuing this and you should be getting whatever money you can, and that can go back to customers. But the idea that the fact that a contract is going to substitute for the used and useful, that's just legally not correct. The used and useful is whether the system is in place, ready to serve that customer, gasified, ready to serve that customer, built as intended. That is used and useful.
According to that logic, couldn't a utility company go out and just build like crazy and say it passed our hurdle test and it has
Absolutely not.
possibility of being used and useful?
And I'll give you
What
an
would stop
example.
you from doing that?
Because there has to be a reasonable expectation of the customer you can't do a hurdle rate if you don't have a customer revenue in the hurdle rate.
Reasonable expectation or an actual realization of a revenue stream from a customer?
Realization of that revenue stream is after the fact, after the prudence determination. You have to make a prudence determination to go or no go with the project. Are you going to move forward or not with that project? You have an internal rate of return analysis you can only perform if there's a specific customer that's on the other side that you're expecting to come on the system. Otherwise, you can't perform a hurdle rate analysis. So I'll give you an example. There was a company in Massachusetts in 1991. They built a pipeline. It used to be, and it probably is the same in Connecticut, a gas company can kind of claim a town. If you build some infrastructure, you can claim a town and say, I'm the server of this town. So in the old days, the gas companies used to go out and build infrastructure without anybody on the other end of it, thinking, build it and they will come. That is not used and useful. That's not going to be used and useful if nobody ever comes and hooks up, because there was never any expectation of a specific customer at the time that was built. For these maintenance and services, there was a customer, a specific customer, at the time that the decision was made. And now what you're coming along is after the fact, you're saying that customer didn't show up. And so now that is not used and useful and you can't have it in rate base, which is really not the right legal standard to be applying to that. That is not the definition of used and useful. Used and useful is when the pipe is part of the system and gasified. It's got live gas in it. How can it not be used and useful when it's got live gas in it?
Who's using it?
That is an after the fact determination on prudence. It's impermissible. Otherwise, you'd have the whole system. And you'd have to be figuring out who's using what part of the system. And is the system sitting there for a little bit with gas that's not being used? Then it's not used and useful under that definition.
I think we've probably exhausted this one, so if you could move on to your next example.
So
Attorney Kim.
I just want to go back. So these are the types of things that because we've just copied the other decision, shorthand, because it's easy to do that, it's impossible to know whether any of these, how this is really considered, right? Because we've gone back to, actually, this language goes back to the draft decision. It's not even from the it's not even from the final decision, it's from the old draft decision. So, so for this one, we are asking that you restore the costs of these because they are part of the gas system. They should be there should be oversight and they should be reporting to on the actions they've taken. They should be taking those actions, but those are not part of the determination, which is what is the rate-based legal standard. Okay? Okay. So let's then talk about, if we can, are you ready?
Go for it.
Okay. Let's talk about FCIC for 1 minute. I don't want to go backwards in terms of just, kind of talking about things you already know, but I need to just go over a few facts just to make sure we all are level set on the facts. So the FCIC is a credit under state law that you can take for certain types of investment. Utilities are the kinds of companies that can make those investments. When you take that credit, you have to have taxable income that you're taking the credit from. Then you have a separate choice of this repairs tax deduction. The repairs tax deduction is a big deal. It's a big deal for customers. And when it first came into being for utilities, back in the early 2010, 2013 timeframe, utilities have what's called normalization. So whatever they're recording for depreciation, they have to have it. They can't take accelerated depreciation except for under some circumstances. So when the repairs tax deduction came into being, it was a big deal. All the commissions in New England, Rhode Island, Massachusetts, Connecticut in 2014 all looked at utilities making the best use of repairs tax deduction, because what repairs tax deduction is essentially turning the rate base into expense, right? So it's alleviating customers of the rate base expense. There's no return on it. It's essentially the same as 100% bonus depreciation. You're just expensing it right off the books. So it reduces rate base. So commissions around New England, they were very hot on making sure that the utilities are taking these repairs tax deduction. And it's a big deal. It's a lot of money. And for these two companies, it was in excess of $100 million of deductions they were able to take. But if you take that deduction, depending on what your taxable income is, you may or may not have room for other deductions, just like at home. Like how much deductions can you take based on your income? So the company had a decision here. Do they take one path or the other? So do they take the repairs deduction, which has a big benefit for customers, or do they not take it and protect these FCIC credits? So they make a decision to go with the repairs tax deduction. So during the proceeding, yes.
Just putting aside the specifics here,
Mhm.
if you have $100 of expenditure, let's call it, which one of these is going to give you a bigger bang for the buck as a ratepayer? If you don't have room for both, which one would you take?
Repairs tax deduction all day long, multiples, yeah.
So you would take all that you can until your taxable income at the federal and the state level is brought to zero. And then you would stop taking that, but now you can't take the other tax credit, state tax credit.
Yeah, I just don't know if it takes it to zero, like there's other things
Okay.
going on, yeah. But theoretically, yeah,
Like things
it's
simple.
taken it to zero, so you can't fit in this other deduction, right?
Right, that's what I'm saying.
That's what this is. So they take the repairs tax deduction. Now, these FCIC credits, they last 5 years. They don't exhaust right away. So maybe you can use them later on. For this company, the ones that they could have taken during this intervening time period, 2017, 18, 19, they didn't expire until 2023, which is start expiring till 2023, which is after this rate case was based on a 2022 test year. So they come to the commission and they say, hey, We took this repairs tax deduction. This is a really good benefit for customers, a big benefit. It's saving for CNG customers $4 million a year. For SCG customers, it's saving $6 million a year. And for SCG, that's saving $6 million a year for customers, the company's asking for $146,000 a year to be put into rates. $146,000 a cost with $6 million of reduced revenue requirement for customers. On CNG, it's $4 million of revenue reduction for customers, and they're asking for $40,000 a year. This is denied in the draft decision. And there's 1,000 reasons why it's denied. And it's denied, it's a new section, it's rewritten, so it's not a copy. It's all 1,000 reasons why the customer should not get, why the company should not get it. The bottom line is you made your bed, lie in it. In other words, what the actual decision says, and I can read it to you, is it says something about, you could have you made an accounting change. It says you made an accounting change. Just let me get to it. I had it written down. Hold on.
Can we also summarize what was the accounting change?
Well, the accounting change was to decide to take the repairs tax deduction. That's the quote-unquote accounting change.
But that's not really a change. That's just doing what you would have done under any circumstances in any other year, right?
Well, they hadn't been doing it, so this was new to them. Because the law had changed, the regulations had changed, so this was a new, and they don't have to do it. It's not mandatory. They can decide one way or the other what they want to do. So if we look at, say, page 165 of the CNG decision, so let me just get there. This is what the order says. The company elected to change its accounting method to the tax basis repairs deduction to take advantage of accelerated deductions. In doing so, the company likely weighed or should have weighed the benefits of the new accounting method against its potential inability to use FCIC. Therefore, it is the company's responsibility to deal with the impacts of its change in accounting method, including the potential impact on FCIC utilization. In other words, you made this decision, you live with it. So I just want to bring your attention to the fact that, the whole section starts off with, this is the sentence it starts off with, it goes through on pages, say, for instance, 185 to 186 for SCG, goes through 3 or 4 paragraphs saying, here's what the company's position is. Then it starts with a paragraph halfway down page 186 in the SCG docket. It says, the authority is not persuaded. Then it launches into this all kinds of discussion about why the authority is not persuaded. Hey, you had the choice. You could have done something different if you wanted to. You have to live with the ramifications. So, but I take you back to not quoted in the decision. Take you back to the decision in 220808, which is a rate case for United Illuminating. And in that case, it was a different outcome. There had been an accounting change that Pura felt that the company should have taken. And the company didn't do this accounting change before. And so Pura calculates that this cost customers $10 million. So in that case, there was an ROE penalty, 5 basis points ROE penalty. And here's just to read you what this says. This also starts with, the authority finds unpersuasive the company's testimony and argument as to why it failed to implement an accounting change that would save ratepayers millions of dollars. The company testified its management develops tax policy and monitors development so that it may act to the benefit of the company and ratepayers. And as the company has conceded here, management drives tax policy. The company has an affirmative obligation to be technically, financially, and managerially expert and efficient. and it must perform its public responsibilities with economy and efficiency. So here, a 5 basis point reduction in the company's ROE is warranted to incentivize management to identify opportunities more proactively and efficiently for ratepayer benefits in terms of the accounting decisions. So we have one order where Pura is saying you're penalized if you have an accounting decision and you don't take the path that's better for ratepayers. Then we have a decision here that says, oh, they did take the path that was better for ratepayers, but it came at a cost to them. And now we just want to recover the cost, which is $146,000 for one company, $40,000 a year for the other company, when customers are getting millions of dollars of reduced revenue requirement on rate base for the decision the company made. So here, I just raised the question of what is the policy that we're trying to pursue? Because yes, the decision you have the power, you have the authority to find that they shouldn't get this. This is a judgment call, no doubt about it. You can list 1,000 reasons like your draft decision says, but where is the message to the utility here? Where's the common sense that they took a decision path that was better for customers by millions of dollars? They have a cost that they're asking to recover. There's nothing unfair or harmful to customers about that trade-off. They made out very well. Customers are making out very well. And the company's been penalized in the past for taking a different path. So we have to have one decision or the other. We can't have it both ways.
Thank you. But shouldn't the guiding rule here be the lowest cost of service, with us substituting for market discipline?
Yeah, but shouldn't it be?
And
It should be, right?
and-
But here you're saying to the company, you actually they took that path. They made that decision, penalizing them for it, right?
well, it seems like they want to net it out.
It's
simplistic.
$146,000 a year versus $4 million a year, or $6 million a year, $40,000 a year versus $4 million a year. So where's the inequity in that? If you want utilities, and they should, I totally agree with you, they should be taking they should be customer advocates in when they make decisions. But now they come along and they say to you, hey, there was a cost to this. It's a small cost. Can we get this back? And the answer is no.
Okay. But even your description of the tax law evolution here kind of demonstrates that companies have to be nimble and make these choices under our watchful eye, hopefully, to check for prudence. I actually have a separate question.
Sure.
Did customers benefit from lower state income tax expenses through this period in terms of how you were accounting for these?
All capital investment is incremental to rates, right? So any changes that are happening are not, unless there's like a capital tracker in place. So for instance, to the extent it was in DIMP, they would have gotten the benefit through DIMP, right? Because DIMP, that would have flowed right through.
But base rates would include a set, for the rate year would be a set amount of state taxes, right?
But this came about as a result of incremental investment, right? The repairs tax deduction arises from specific investment happening in that year. So this would have been incremental to that. So the tax credits were generated just as they were expected. It was all about when they could be used. But because they substituted this other deduction that arose in that year, then they were unable to use that same credit. They have it. Yeah.
Okay, but the companies continued to receive the state tax expense that had been included in revenue requirements.
But I don't want to get ahead of myself, but my understanding, and I think we answered this, seems like you're saying there was a benefit to the companies because, there wasn't. We answered this in our written exceptions. And I can confer and get you a better answer, but I think what happens from an accounting perspective is well, first of all, your order says they're flow through. It mentions flow through accounting. They're not a flow through company. You don't have to choose flow through. So that's a wrong fact to begin with. So no, they did not, whatever the impact of this was, it gets offset by something else, so there's no bottom line. I need to check with somebody on that, though.
Just as an aside, does it get a little complicated because of the corporate structure? You know, there's a consolidated tax return, correct? And so then companies have to feed up their, if I'm saying it correctly, their liabilities and,
Yeah, you have
Yeah,
some
to the-
language that's new here about something having to do with the consolidated, but the years it mentions is 21 and 22, which are not the years that this has anything to do with. So can you make this complicated? Can you make this be like, okay, there could have been 1,000 permutations, there could be 1,000 beans over there or beans over here? What is the message you're trying to send? Like, what is the ultimate decision here that you're trying to make? The company did the right thing. They did the right thing for customers. They took the bigger, better advantage. They're incurring a cost, a small cost because of that. If we're really coming at this with open minds, given the whole context of the whole order and everything else going against them, why isn't this a win? It's a small trade-off for a big customer benefit, and you're sending the message, too bad for you. You made your bed, you lie in it.
so you're confirming right there that there's a trade-off. And in other words, you still want to sort of net it out. You made your decision, but you're trying to have us ask customers to pick up the tab through a deferred vehicle, you know, for the,
They got the benefit. It's asking that it's produced a net benefit now. If it didn't produce a net benefit, no, right? But it produced a net benefit for customers.
a
So
net benefit, but like the word net depends on what we decide to count.
it depends on what,
Pluses and
sorry, I didn't.
pluses and minuses, right? Those are, yeah, okay. All right, I think I'll stop there.
So just your words today sound like what you're saying, and maybe you're not. Sounds like you're saying we took the tax repairs deduction, and then in a couple of years, because we did that, we couldn't take the state income tax credit deduction. So now we want to get paid back for that. Why do you get paid back for just not taking something?
No,
That's what it sounded like you were.
yeah, okay, totally get what you're saying. The credit was generated. The credit was created. It came into being. So, but it has to be used within 5 years.
Understand,
Yeah,
expired worthless. So
yeah.
didn't it in those years?
No, not till 5 years later, which
Right,
is
right.
more
But
recent, yeah.
doesn't that mean no one ever used the credit?
Yes, it means it did not get used.
Did not get used. So who benefited? No one benefits from not using
The
it.
customers benefited all day long, because the reason it didn't get used and couldn't get used is because the company took the repairs tax deduction instead. So customers were 100% the beneficiaries of that decision. In fact,
Why doesn't it become irrelevant, though? If you take tax repairs deduction and you carry forward 5 years and then it expires worthless and no one got the benefit,
because
Why isn't that just
because
the end
it
of the
was
story?
because customers had the benefit. Customers,
they had the benefit of the tax repairs deduction.
they also got the FCIC and rates. They got two benefits. They got the benefit of the reduced tax reduction, the repairs tax deduction.
Saying going back in time, once upon a time, people assumed that the tax credit would happen, so it got embedded in rates, and then you roll forward and it didn't happen, so therefore that's where you're claiming the inequity is.
Right, but we're not trying to go, these didn't expire. If they had expired like in 2 years, that I don't think the company would be asking for, but these expired in 5 years. So they expired after the test year, and at the point that they were in front of Pura, asking only for the stuff that had expired after the test year, and saying, okay, this is a cost to us, because customers got two benefits. They got the benefit of the repairs tax deduction and the FCIC. We're glad we took the repairs deduction for them, but they got a benefit that we didn't get the flip side of it. So we're just looking to even things out. We're asking to even
When you
things
say
out.
you didn't get the benefit, you mean you did not get the benefit of putting it on your tax return,
Right.
and therefore recovering it separately.
Or using it some other time.
In your tax return, is that a Connecticut standalone return that we calculate all this on, or does it, because you have other like, we're thinking about two gas utilities here, and you have other companies in the state. Does it all get kind of,
I think it's
mixed
probably
together.
consolidated, but let me just confer if you don't mind. Okay, yes, it's a consolidated tax return, yes.
so when you don't have taxable income to use it, is that 100% attributable to the fact the gas utility didn't have tax?
Yes, Mr. Hurwitz just confirmed that all the numbers here are just for these utilities.
Sorry, and
Yeah.
everyone else in the room knows this, but
Yeah. There was something else I might have was thinking was important. Okay, I guess that's it. I think, okay, I guess that's it, unless there's any further questions. Okay. Okay. I just need 1 minute here. I'm like so off track. Okay. Um, Okay, so just kind of tailing off of the FCIC, one aspect about FCIC that Pura did fix in this decision is now let's think about going forward. So the draft decision is good in that it says here going forward, the company will record when it's able to use the FCIC, and it will keep track of it, and it will record that as a regulatory liability, meaning it's owed to customers with carrying charges at the weighted cost of capital. So if the company invests money and gets that credit's going to go to customers. All good. That's how it should work. It should work prospectively. If the companies get it, customers get it. But what's associated with that is rate year capital. So rate year capital is a difficult issue right now in Connecticut. I'll just say that. Because in the past, Pure always allowed rate year capital. If the exercise is that we're trying, all rate making is prospective, as we said earlier. So when you're setting rates on a historical test year, you come in with your test year costs, you then are making some adjustments to bring those costs forward to be representative of a company's cost in the rate year. So Pura was great in the past where Pura would recognize that there will be capital investment in the rate year. And so they would put an allowance into rates that would cover the revenue requirement for that. And the determination of whether that capital is used and useful is a fact determination. That's a fact determination for the commission. So what the commission would do is say, would allow it, and then in the next case, they look and determine whether or not the company had actually spent that money, did they budget it right, and then there would be like an adjustment. So that's a policy decision to do it that way. Rhode Island does it that way, Massachusetts does not. Massachusetts uses a lot of trackers. Rhode Island sets rates just like Connecticut used to do to include this. And if a commission is looking to have set rates that are representative and are going to keep the utility out for a few years, then they're going to include rate year capital. Another policy may be to decide, I'm not going to give you rate year capital because it's not used and useful at the time I'm setting rates, and I'm going to make that determination. So Pura has switched gears on this since the last commission was here. Always up until about 2023, I guess, they would allow the rate year, but then in the Aquarion decision, no, change the policy. So one issue here is that in these particular cases, that rate year is passed, right? So there is rate year capital that's used and useful in service. And in this record, no new evidence. This record contained a whole bunch of documentation supporting those projects, contained all the information to look at whether or not what was planned, what was going to be put in, and proposed a reconciliation mechanism that said, we'll reconcile on a monthly basis to show you that customers have never paid for investment that wasn't used and useful at the time they were paying for it. And the way that would happen is that customers pay rates over 12 months. So if there's $100 that you're collecting in a customer bill, you don't collect $100 in January. You collect $100 over the course of the year. So what the company's proposed, recognizing that the commission was concerned about rate year capital, concerned about this used and useful, they said, how about if we give you a mechanism that shows you what we're putting into service each year and has that true up so that customers are never paying for rate year capital that isn't used and useful. That was the proposal, got rejected. Now you come along here in the draft decision, there has definitely been, this is now in the past, there's definitely plant that's gone into service, and that reconciliation mechanism could be used at this point to allow the company to get that rate year capital and to reconcile it through that mechanism.
But by the argument you're giving now, isn't that violation of our terms of time travel?
Why does that?
Of course, we have more information now about what actually happened.
The only new information I'm suggesting is that the time has passed.
Okay, so we're going back in time and we're looking at this proposal and we decide, is this a good idea or not? Is it a good idea to have outside of an atypical inclusion of rate base for plant that's not yet used and useful, and may not have been subject to a prudence determination either, in a historical test year state that has mechanisms like DIMP and revenue decoupling? So again, isn't this a policy choice and I realize there were good old days, I get that. But isn't this a policy choice that we can and would have made, conceivably in this, that we still did not, we didn't want to go that route. And also, on top of that, I mean, this wasn't a multi-year rate plan, correct?
No.
So in other words, again, I mean, the normal course in historical test years, you come back and
But the commission still had an obligation here, still has an obligation to set just and reasonable rates. And so at this point, given the passage of time with no new evidence, the evidence in the record, now granted, I agree with you, policy call, judgment call. I'm just again asking, why did every single decision go against the company? Why every single one? And let me tell you why this might be good for customers. Because what happened in the last case is there was the credits. As you know, there's these big credits that have to go back. Between the two companies, there's $40 million in credits, $10 million for CNG, $30 million for a year for SCG. In the next rate case, before you even get started, the customers are going to experience a rate increase just because those credits got pushed back so quickly. They caused a credit downgrade because they flushed the cash back to customers. They reduced rates like over 3 years. These big amounts went back to customers over 3 years. They're almost expired. They're going to be expired by the time new rates are set. So customers of both companies are going to experience an increase before you even get started on the next rate case. So actually a stabilizing impact here could be to decide under the unique circumstances that exist here, that because it is a historical test year state, because we do have that principle, we would actually allow rate year capital here because it is now historical. We have the evidence in the record and we have a proposal for a reconciliation mechanism, which is rejected in both draft decisions, no change from the original, cut and paste. So who knows whether it was actually considered or thought about this way. And so here would be an anomaly. It wouldn't be changing the policy of the state and going back to rate year because this is very unusual that we're in a place where that is now historical. And there's a reconciliation mechanism on the record, no new evidence that can assure this. And if you did it, if Bureau were to allow this increase, it actually would mitigate what those of how much has to be put into rate base the next time, because otherwise this is all going to get lumped in the next time and add to the increase in the future. So customers are already going to feel this shock. And this would be, I'm just trying to raise the other side of this, why there is some benefits for customers to allowing this. There's nothing now untoward about allowing the capital investment that has occurred in the past that will go into, is in service and will go into rates the next time.
If I may, so, but those credits are going to expire, rates are going up regardless of what happens here.
Regardless,
So
that's my point.
so
They're
that's
going
gonna
up
happen.
no matter what, right?
And I also, I thought I heard you say, who knows whether something was considered, and I hope you'll agree, you actually don't know.
I don't
You
know.
don't know.
I don't know that it didn't happen, and I don't
don't-
know that it
okay,
happened.
all right.
100% with
Okay.
you there.
Now,
Yeah.
so back in the day when utilities would face major capital projects, I'm talking about like integrated, utilities,
Yes,
commissions and regulatory policy recognize this with use of like construction work in progress or AFUDC, because there was an understanding that there had to be some relief in the course of a multi-year, construction project. But what we're talking about is a little bit different for distribution-only systems, right? I mean, in other words, there's an expectation of, that continued investment, and you're getting, depreciation expense, you're getting through rates, you're getting non-cash cash flow from that, and so on. So,
well, let's,
yeah, I guess what you're looking for, like, just greatly reducing regulatory lag and the risk that goes along with it.
we're not looking to reduce regulatory lag. Here's why. Those projects are depreciating every year, right? So when they go into rates, they go in at the book value at the time they go into rates, they're depreciated. So we're not shifting, the company's already incurred costs that it cannot ever recover in relation to these investments. I think the other thing that happened in this order and now is maintained here without change is depreciation expense got cut by $20 million for one company, by I think it's 12 million for the other, got substantially cut down. So when you say, okay, there's an expectation that these are like the regular distribution, we had two things going on at the same time. That got denied out of rates. You don't get to recover your rate year capital, and the depreciation got cut substantially, which never happens. It never happens that a commission is cutting existing depreciation rates by so much. And the problem with that is that needs to be thought about looking forward is if you don't depreciate rate base, customers pay more because a return is paid on rate base, right? So if you depreciate rate base on the time schedule that is appropriate, then you're accomplishing a bunch of goals.
They pay more in return, but they pay less in rate depreciation expense.
Correct, but over time, you're reducing the need for them to pay a return on rate base, and you're assuring that the customers that are using the property are paying for it, right? So you keep generational equity, you reduce the amount of return that's going to be, it's to customers' benefit.
Okay, since you brought up intergenerational equity, and that is part of the authority's determination of when setting depreciation rates. It's obviously a core issue. There's asset life, and there's intergenerational equity, and there's return of capital, and there's salvage. Those are kind of four things we think about. But intergenerational equity is relevant at both ends of an asset life, right? I mean, in other words, you don't want to front load and you don't want to back load, and you take the evidence in front of you of what it's costing, especially with regard to the salvage issue, what is it actually costing? Wouldn't you agree that wouldn't you agree it's a It's, there's a lot of judgment call for both companies and regulators.
100%. And there isn't a regulator that's walking the face of the earth that hasn't cut depreciation expense in order to keep that revenue requirement down. And there's not one company in the world that is going to complain too much about that, because depreciation expense gets booked, whether it's approved here or here. It doesn't affect their bottom line. It just becomes, it's all a matter of, here they were cut so bad it caused a credit downgrade because it affected the cash flow of the utility. It cut it down so bad. I think in the long run, it is not in the interests of customers, because as you're balancing customers paying depreciation expense versus paying the return on rate base for longer and bigger, like you have to weigh those things out. I think going back to the rate year capital, this is what a commission, these are the decisions a commission has to make, that you can short this. You can short this, but customers pay in the long run. And we have to think about the efficiency as if you're going to have, and this goes across all rate cases, and I say this to OCC, AG, if you're going to set rates for the rate year, essentially below the company's actual cost of service by not contemplating the capital investment they may have or other costs, inflation, which is now cut out 100%, and we'll get to that. If you're going to set a rate year cost of service that is so, I'm going to just say so tight, let's say it's that way, very conservative, right? Let's call it that. That's a judgment that the commission can make. Right? I'm going to say I'm historical commissioner. I'm going to stick with that test year. I'm not going to make any changes. That utility is going to come and file every year, because they're going to have to keep trying to align their costs with their rates. A commission therefore might decide, which is where commissions get to in thinking about rate year capital or inflation adjustments or other judgment calls on depreciation. Might decide it's not efficient for me to be setting policies that have every utility in the state trying to come in every year or every other year. Like, this isn't efficient for customers, and it allows the companies to update their costs that they might not otherwise be updating in rates. So this is the call that has to be made here. But when you issue a decision like this draft one, that everything is against the utility, there's not one thing that we're saying, that we're giving here, that balances that off and says, we're looking to set just and reasonable rates in this rate year, regardless of everything that happened. And we're going to make some policy decisions to do that. The decisions have to be different than what they are in the draft decision. Okay, so let me just talk about, sorry, just let me look at my list 1 minute. Sorry. Okay. On depreciation, I cannot explain it all to you. I wish in the final decision you would get rid of this net salvage thing that OCC's witnessed. The company, I don't understand the whole thing, I'm not going to profess to, but the company cannot recreate the numbers. We've asked over and over again. It doesn't, there's no record to support the calculation. That is what's causing the depreciation expense to be lowered so much. I would just ask the commission to consider dropping that net salvage adjustment.
As long as you're bringing that up, Attorney Kimball, because I'm glad you did, and there's been some dialogue about that. It's just an interesting topic, the whole issue. And my sense of it is, again, if we went way back in time, salvage might be a positive number, right? You might get some value for metals and whatever. So there was this sort of optimism about, hey, we'll get salvage. So you really didn't have to think so hard about it. But now we pretty much accept that a lot of times it's a negative number.
Right.
And it could be a big number if there's an environmental issue, but it also could be a really low number if, for example, you can just leave pipe in place, if you can do that in an environmentally responsible way or something like that, that there may be very little cost. And I think that's an issue that witnesses have raised and, about these things. And, but I am wondering, your comment like triggered this out for me, like going forward, this is something parties might consider is, are we doing this the right way? Is there a way to maybe, now that there's rules about asset retirement obligations, also goes over my head, but, and there's these issues around salvage and so on, like that maybe there needs to be some thought to separating them. I think sometimes people even think they see this accumulated depreciation reserve, which is sort of an arcane term, and think that
Exactly.
you guys have a big pile of money
Yeah,
somewhere.
what's
that
going
we
on
can-
with that, right?
Exactly, what, and so I think even the language around it can be really confusing. It's confusing, put that number, and I don't know if Commissioner Smith, it's something you and I have talked about, this issue of salvage. It's maybe something that going forward is, I'm just throwing that out there, something we could all have some conversation about.
I think it's a very, very important issue. It's right, very underrated issue. I love that you're picking up on it because for gas and electric utilities, the world is changing. Like what the equipment that they're putting on the system, how they're investing in the systems, like I think there's a lot of issues around how, and like I said before, like if we're worried about affordability, like should we be looking differently at depreciation? Because even though, like you said, it does have a rate impact today, it does cut down on a whole layer of costs that customers will pay far into the future. So I think there is a lot of issues around this that, and like you said, when you're holding back on depreciation and you're using it as a tool to keep rates low, which is why I think this came out this way in this original decision, no changes made to the dialogue in the draft decision here, is that it was made, these cuts were made for the purpose of just cutting rates. And so and this would be a particular issue. I can't wait to be in another rate case with the depreciation witness. I hope you ask 150 questions because this is going to have to get explored. And this is one issue where you can't watch YouTube and really kind of figure out like what is the right decision. It's too intricate.
I agree, but we would of course rely on technical experts in the room to do the cross-examination and help us in our fact-finding journey. I just want to note again, you've speculated as to why we made this decision.
I am
And
speculating,
I
yes.
would just take note of that because it's.
But I don't have any option because the dialogue in the order is a cut and paste. So we don't know. We don't know we don't have any way of knowing, we'll never know. I'm just raising that as, that's our perspective. You have another perspective. This is somewhere in the middle is where
Yeah, so
it lies.
it's a really, something to be careful about reading, reading something into something and attributing motives, but
I don't want to have to chastise this panel the way I chastise the Attorney General, but we may have to go there, so.
So, excuse me.
Go ahead.
Just picking on the little tangent, if you don't mind. In the future, and I got to pose this as a question, I think the way this works, but so the whole net salvage value thing just, it seems ridiculously confusing to me. Everyone argues about it. We don't know what the future holds. I don't understand why we don't depreciate down to zero on original costs and just take the actual salvage value each year and expense it. And if we're worried about lumpy shocks, maybe spread it, have a rolling 3-year average or something. So now I'm asking a question. Do you ever think about things like that as possible solutions to part of the depreciation dilemma?
I wish I could claim to be smart enough that that's what I think about. I understand the concept in net salvage, and I think that listening to thinking about it being over 3 years, I just think part of the principle is spreading it out over time, along with the life of the assets. And the part of that equation is the idea of what people are going to pay in the future, that it's not all stuff that's been taken out today. It's it's like, you probably Commissioner Beecher knows better than I do, but I think the concept of net salvage is that you're kind of putting something away in the bank for later. Like it's not all related to today. It's accounting for things into the future. I don't have an answer beyond that. In a rate case with live witnesses, it'll be an excellent question. Okay. The last thing I just want to mention is inflation. So the inflation adjustment, it's I don't know, it's about $2 million or whatever for each company. So again, another easy thing to take out. But Pura has been all over the board on this. And again, the idea is we're setting rates for the rate year. So We researched, we found examples all over the United States of America, Michigan, Illinois, Rhode Island, Massachusetts, Maine, where it's called the residual O&M adjustment. So you have O&M expenses that are going into the cost of service. Some of those you're making known and measurable adjustments to, so those don't get an inflation adjustment because you're adjusting them specifically. And then you do a residual O&M inflation factor, which just kind of is intended to bring those costs forward from the test year, which in this case was 2022. And the rates are theoretically going into effect November 1, 2024. So there's a 2-year gap. And so it's a rate-making mechanism. And for some reason now in the draft decision, it was actually granted in the final decision, and now it's taking it away. So again, a rate-making decision, but really every rate case always has some kind of residual O&M inflation adjustment. So why is this just being taken away? Like, it's hard to understand why it just goes to zero. And so, and where Pura has, we went back and looked at, like, even in the Aquarion, the famous Aquarion case with the $4 million reduction, $2 million inflation adjustment. Now, the parties will argue over what's the inflation factor you're applying, to what time are you applying it. Those are all things that we can talk about and litigate, but to just take it out and take it to zero is just contrary to rate-making practice. So why is that happening? So that's my last issue for today. And again, I just go back to, this is what we experienced before. Non-standard rate-making practices that changed all over the place. You never knew coming into a case what was going to be the standard this time. And so just for some of these rate-making practices like inflation, if we just could get back to a standard, that would be great.
Okay, so let's pause on that. And Attorney Kimball, you really messed me up because I had 12 pages of questions, and now I'm going to have to edit while I talk, and my commissioners are looking at me wondering what I'm going to do. But let's talk about this expense issue a little bit, since that's your last topic. I mean, this one and depreciation are good examples that we didn't actually duplicate the order, right?
Sorry.
So, that's okay. So we, I mean, with both expense and depreciation, we didn't duplicate the order.
Depreciation, I think, is pretty close. Yeah.
Sorry, O&M in particular. But ROE, DIMP, we didn't duplicate the order. So, but in expense items, yeah, we had several considerations here. So you brought up rate making standards, principles. And I mean, isn't known and measurable a pretty firm rate making standard, and one that, sort of, for pro forma adjustments in historical test year, you want some evidence, you want something that you can count on. So just as one example, you're asking, I believe, to inflate corporate charges. That one that's one that stood out to me, because how is it that you could not, being part of this entity, this is not like somebody you don't know or some vendor you're working with or something, it's your own corporate parent. Like, how is it that they could not provide you with a copy of the upcoming bills? Or is it?
Yeah.
It goes up and down though, right?
Super good question. So, because I see two things in there that Pura has been struggling with here on this issue. So known and measurable is the gold standard in my book. If I'm meeting with a client and they've got a rate case and they say to me, oh, here was our expense in the test year, but now in the year after we have a new contract and we're going to pay more under this new contract. So it's a known and measurable change and it's a major cost expense. Maybe leak surveys, for example. I've seen that where a gas company sends it out to an outside contractor, has a contract in the test year, but now has just done a new contract, so it's going to increase. Okay, so great. So we put that in the case. The known measurable, beautiful. You put that in the case. But if you're going to ask, so that then becomes a known and measurable change, not eligible for the residual O&M. It has to get taken out of that cost has to get taken out of the bucket that's the residual O&M change, because the only thing left in the residual is O&M changes, O&M expenses that you're not otherwise changing. So Pura was kind of going down a trail where they was like, okay, you got to bring everything in and everything has to be a known and measurable change. But for these companies, you're talking about hundreds of contracts across the business, hundreds. Like, so we just go through a storm proceeding where we get an order that says, too much maybe there's some times when there's too much documentation. If you're gonna reduce O&M to like, you have to bring in all your contracts, this is gonna be like a great, no, you can do that, we can do that. It's a different way of coming at it, but what commissions have decided is it really worth it? Because it's the inflation adjustment is $1 million, $1.5 million, $2 million. So is it really worth, is it efficient to bring all these contracts in and plow through them? And it might even turn out to be more than just doing the inflation adjustment. So for these residuals, we do a rate-making strategy or a rate-making protocol of taking the residual bucket, the non-adjusted bucket, and we say, okay, we're going to bring that bucket forward from the test year to the rate year, and that's going to be our representative level. So two different ways of doing it. Now, you raised corporate. So that is one area where what Pura has done is Pura has said, well, we looked at the past 3 or 4 years, and those particular charges haven't increased, right? Those are not just like standalone expenses. So Pura's made some adjustments on inflation on those particular expenses. But I think that for which we're not contesting, but where is the inflation adjustment on the rest of it? It can't be measurable. That's not going to be efficient.
Okay, and so, but the thing is with inflation, you have to use some broad metric, and some things, go up, some go up more than inflation, some things don't. And so, that I think that's the struggle, is that it's, it's not known and measurable. And when you're selective, you're likely to be selective about the ones, the bigger ticket items that you think are going to go up. But then ratepayers don't get the benefit of the totality of what's going on in terms of efficiencies, for example, that you might find that could offset inflation. And also, the lack of an inflation adjuster does impose additional incentives and pressure for cost control, because you'll be looking for, say, if you've got an option to make a purchase decision, you might be trying to mitigate the effects of inflation through your strategic.
Working with utilities, and I would assume this might be true for general business, there's a difference between incentives working when you're treading water and incentives working when you're underwater. So if you're going to set rates that just deny a whole bunch of costs, deny inflation, you make it so that those rate year rates are not representative of a fair cost of service, and the company just becomes underwater, the incentive doesn't work. That incentive that you're talking about for greater efficiency doesn't work. They get ready for the next rate case. They just bring and bring in their costs and have it trued up to whatever they can show in the test year. If you're really looking to promote efficiency, you actually will get more out of a utility, or probably even a business, if you can set their costs, their price at a fair and reasonable level in that rate year, so that they can have an opportunity to make the combined package of what they're dealing with work. So that's just the fundamental rate-making decision of policy that a commission has to make. Am I looking to try to look at every line item, and am I trying to make sure that they don't get inflation on this contract or this cost or that cost? Or am I trying to set rates that are reasonable at a reasonable level by having kind of like an inflation adjustment that I don't spend all the time going through every line item, but it tries to approximate that cost between years and tries to set rates at a level that they should be able to live with for a few years. Like, that's the difference.
Okay, thank you. But you'd agree that our job is not to micromanage you,
Absolutely agree with
it's to
that.
set up a
Right.
system
It's
of.
to set up incentives, right.
Right, and so as we're, it's hard not to get into micromanagement when you're picking and choosing items to inflate or not to inflate, and contracts to inflate or not inflate. So it gets pretty complicated. I think we absolutely agree on that. Let's see. Let me just take a quick look. I think I will pass on some of these for now unless they come up later. You do offer some novel ideas for a few things. I may come back to that. Let me see give me just a second. All right. Thanks for your patience. So I'd like to actually go back and, like I said, I'll try to be reasonably efficient. Because I did read your motion and your exceptions really carefully, so you know that. So I actually just want to take up a couple things, and some of which we've already touched upon, but it feels like, your concerns center on the decisions that didn't work in your favor. And so you're sort of extrapolating from that, to borrow a term from another proceeding. You're, to sort of suggest, maybe, I don't know, that maybe you didn't get the deliberative process that you were hoping for. But did the, and some of these questions, by the way, I will hope that our other parties will comment on later when we get to them. But did the Superior Court question our fact-finding authority or capability in this to rehear this case? Did that come up at all in the judge's direction?
Okay, so I'm prepared to address, I was going to actually start off with this and I took it out because of our prior discussion. What really happened, what the court did say, and I have the decisions in front of me and others can debate it, but when we filed with the court the appeal, the op-ed got published the same exact day that we filed for appeal. So when we filed our appeal, we did not know that the op-ed was going to exist. We filed the appeal. We had concerns about procedural irregularities, the motion rulings and all these things. The op-ed came later. It came after it came the day we filed the appeal. So sometime, and I forget the exact date, maybe in February of the next year, we filed the appeal December 19th, same day the op-ed was published. We filed a motion for discovery to look into, on Pura, to figure out what had happened with the op-ed and also on the procedural irregularities. And in that ruling, allowing discovery, the judge said that the reason they were allowing discovery on the authorship of the op-ed was the court concludes that a disinterested observer could conclude that the author of the op-ed in question could have in some measure adjudged the facts of CNG's and SCG's applications before hearing the case, which is to say prejudged whether the requested rate increases were appropriate. So you have orders that started off by saying these are companies with sustained over earnings. They deserve what they got in the original final decisions. So by the time it got remanded, though, circumstances had changed. It got remanded November 19th, 2025, 2 months after the change in the commission. But the judge started off its ruling by saying Pura now admits that former Pura chairperson Marissa Gillette violated Connecticut law in how she conducted the underlying administrative proceeding, and her actions prejudiced the substantial rights of the plaintiffs. So he goes on and says, so we're going to send it back, and, we have all that. And he says, the decision is remanded back to Pura for entirely new rate proceedings in accordance with the findings of this memo and in compliance with applicable law. For clarity, the court finds that the procedural errors and irregularities set forth below have so permeated the proceedings, the evidence, and record below as to undermine the fundamental fairness of the proceedings below and deprive CNG and SCG of a fair hearing. So the Pura is going to look at it as if newly filed. Those are his words. At the very end of the ruling, he said, the companies were saying, well, what about this bias thing? And he said, what's going to be your ruling on that? And he said, as Ms. Gillette will not participate in the new hearing or the compilation of a new record, and any claims to her alleged bias are moot. In other words, she's not there anymore. She's not the decision. You got new decision makers, good decision makers. You're going to be all set. Newly filed case. All good until we get a draft decision that is verbatim. So it feels a little bit like, I'm not saying this happened, you're not going to like this. I'm just telling you the perspective. It's as if you have a student that filed an exam, put an exam in, intricate. Every single issue goes against the utility. Every single issue is got the evidence, got the argument to go one way. And now that student is kicked out for cheating. And now here comes the same test, the same exact test, except for worse. So you have a situation where the judge found that those original decisions a disinterested observer could think that the outcomes were prejudged, that there was over-earning, and so therefore these had to be reductions. And now we get to a point. I am 100% agreeing and understanding this is not how you view it. You did so much hard work. You came at it all new. How does it come out all new with all the same judgment calls as the person that left the room for bias, prejudgment, and pervasive irregularities in the record, the compiled record? And so all I'm asking today, all we're asking, I didn't even raise rate case expense. Didn't I do good there? I don't even care. I didn't. Because all we're asking for, can you consider a few issues that have larger ramifications, that have policy ramifications, if you're truly looking at this with fresh insight, with fresh desire to balance things out? Could we please look at the FCIC benefited customers in the millions of dollars? The company did the right thing there. They're getting penalized. Can we look at that future rate year capital, which is now not future? We have a reconciliation mechanism that could be used to make that work. We have depreciation that got cut in half. And we have quote unquote unused mains and services that we're applying the wrong legal standard to. And it's unclear to me who is giving you legal advice. That's what I'm asking you to reconsider those decisions in the vein of we're trying to look at things and balance things out. That's what we're asking.
Okay, since you went there, and the presiding officer has discussed with the panel how we'll approach the motion at the appropriate time. But so with respect to the dockets, it looks like the essence of your argument in the motion is that under the prior chair, Pura staff served and performed their duties at the will and direction of the chair. Would you agree with that?
Yes.
Okay. With respect to dockets, is the essence of your argument today in the motion that this quorum, which also happens to be a majority of co-equal commissioners, that we serve and perform our duties at the will and direction of the Pura staff?
Absolutely not.
Okay, let's just move on. So is it, in some ways, one could also see this order making these new tough decisions as proof, actually, that we're looking anew. So one could read the order that way.
I've never seen a rate proceeding where the advocates, the consumer advocates, had absolutely nothing to complain about on a draft decision. Show me another case where that has happened.
Okay. For you, it's inconceivable that a new panel, considering the same record evidence for the first time, could independently deliberate, make a finding, and reach a decision comparable to one previously considered by the authority, including with respect to the various choices we've already talked about. Is that just inconceivable?
No, it is thoroughly conceivable that that could happen if, for instance, I would believe that a lot more if I knew for a fact that people that helped write the other decision were not advising you on legal precedent, legal policy, legal ramifications, and having an interest, a self-interest in protecting what went before, in proving it to be right.
Okay, I'm going to stop this conversation here, if I may. I don't think we're going to advance the argument, and I apologize to Commissioner Beecher, because I think we are going to reach very different opinions as to the outcome, the motivation of this panel, and the professionalism of Pura staff. And I think we're verging on a line of impugning their professionalism and reputation, and I'm really be very uncomfortable with pursuing that line in this hearing room. So if you would like to continue, Commissioner Beecher, and we'll move on from there.
Thank you very much, Commissioner Cheeseman, because I want to move into exceptions now. So you mentioned that you are disappointed and frustrated. Actually, I kind of think that's in our job description, so it's kind of what we do.
Yeah.
In fact, we teach that, right? That nobody's ever happy.
But somebody is happy here, right? Right?
They're
It's-
happy.
That's not true.
Yeah.
Yeah.
They've been overworked lately too, so. Anyhow, so yeah, we understand your problems, and I do appreciate your color-coded table too. I didn't see a table 1 in your exceptions, but I did see a color-coded table 2. So I want to go over a couple things.
Okay.
You identified 32 issues, 11 had been corrected in full or in part and remained unchanged. 13 remained uncorrected, your term. 5 were changed in ways you opposed, and 3 were changed in ways you favored. Does that sound about right?
Yes.
Okay, good. So from your perspective, as compared to other parties, corrections, the term correction means asymmetrical and only serves to increase revenue requirements. Is that right?
Sorry, could you just say that a little slower?
Yeah, I'm sorry. I'm trying to pick up time here. So a correction is only an increase to revenue requirements in your view.
Yes.
Okay. So let's just look at the numbers in this case, because I had to like get in the spreadsheets and like I'm trying to understand this. Okay. So this is what I see. And I'm going to inappropriately combine the two companies as if they were consolidated companies, so I don't have to read two
Okay.
sets of numbers. So I see a net increase in the combined rate base of $4.4 million. That's an earnings opportunity. I see an increase in the weighted average cost of capital, or the ROE, of $650,000. I see a modest net positive increase across all flow-through tax components of $113,000. I see more than doubling of the annual dim cap from $84 million to $201 million for 2027. I see a modest decrease in the depreciation expense, actually, of $167,500. And then I do see, along with you, a substantial reduction in O&M and company rate case expenses of $3 million. The net reduction is an overall collective revenue requirement that you already described. And in that context, the companies still owe ratepayers credits of $120 million. That sounds about right, right? Okay. And so again, I don't see how these findings and conclusions duplicate those of the prior order. And I'll also point out something else. As you can see in tables 1 of each order, when those credits owed to customers, owed to ratepayers are extinguished, you're getting the proposed decision is approving 95.4% of the company's proposed revenue requirements for SCG, and 91.4% for CNG. I don't see how this is not a remarkable win that gets high fives at the AGA meeting when you're in the 90% of revenue.
That is not accurate. So
Okay.
that's not accurate. So
Okay.
I'm so sorry. So you ran through that super
I
fast.
did.
And I don't want to make you go back. I don't even, I'm not exactly sure how you've added this up, so I'll look at the transcript and try to
Sure.
figure it out. How does a company that proposes an increase, like CNG, both companies proposed an increase. You're saying, you just said that CNG got, what, I'm sorry, what was your calculation, 91%?
If you look at table 1, after the after the credits owed to customers are extinguished.
Yeah.
Starting in 2020, late 2027. You can see what your approved revenue requirement will be, right?
In table 1?
Table 1, not of the exceptions of the orders. I'm
Oh,
sorry.
table 1 of the order.
I'm
Oh,
sorry, I've shifted to the orders.
okay.
So in the orders, that's where you see a summary table, and I've gone over this a couple times. Because again, to me, it looks like you're getting, now again, I fully realize we are now a few years from this time frame, and I'm sure your costs have changed over that period. But if you look at those tables and you look at your request relative to what we're granting here, and it's hard to reflect the benefit that comes along with DIMP, right? But it certainly, DIMP certainly mitigates some of your cash flow and risk issues. It's considered credit positive.
Requires more money. You got to pay out more money in order to get it back.
Sure,
Okay.
but you will be paid back. I mean, I think that's,
Okay, but it's separate from all of this here.
right, it is separate, right. So again, if you look at that approved revenue requirement, you look at the first column,
Yes.
company proposed 479 million, right?
Okay, I got that.
Over to the right,
I see it.
after credits, 457. That's pretty good.
That's, and which company is this? Let's just check.
Oh, I'm sorry, I
This is for CNG, SCG, correct?
believe so. Yep.
Okay.
So just, but anyhow, those summary tables are in there for a reason, and I think they are to highlight.
So I'm
know-
not exactly sure if that math is correct. I'd
Okay.
love to, I'm sure we're going to hear from other parties, and I'd
Okay.
love to have 2 seconds to be able to check with the company, but I look at it this way. Take CNG. They asked for an increase. They got an $18 million decrease the last time, putting aside the customer credits. Forget about the customer credits.
Right.
They asked for an increase. They got an $18 million decrease. You've made a $20 million decrease, putting aside the credits.
I just want to make clear, we're verging into SCG's oral arguments.
Oh, okay, sorry.
That's my fault, because I
Yeah.
grabbed the first order
Okay.
I had.
I'm sorry.
But
We'd like
so
to,
we can separate that. So
Okay.
that's why I kind of gave them combined, and then, you
Yeah.
know, but just as a general proposition,
Companies are not getting 91% of they asked. I don't know what the right number is right now. I can confer with the company and be able to come back. I thought when I looked at these tables, when we were preparing written exceptions, that the reason I put a different table into ours and asked the team to put together especially the table that's at the bottom, not the color chart, but the chart underneath that says summary of revenue reductions, because it wasn't clear to me from this table that we were set on what is exactly happening here. This table is confusing because you've got you got credits mixed in here. So I check with a numbers person. I'm so sorry. Like, this is the depth of my, yeah.
and the credits are in there because that's still money owed to
Still
ratepayers
correct.
based
Yeah.
on
Yes.
non-firm margin and tax issues, I believe, and they do affect the companies differently, so we don't want to go there. I just throw that out there because, you know, that's what I'm seeing. But again, when we do rate making, we build up. We build up to the number.
Uh-huh.
We don't, it's my philosophy is we don't start with a number or a goal or anything like that. It's a iterative process of building it up, right? And running the numbers. And so that's what we did here. So let me talk a little bit about some of your other issues maybe. I think
Sure.
FCIC, I've had enough, and I'm sure you have too, everyone. Land additions, let's see. I mean, this is a running theme in some of your comments, but are we bound by prior Pura decisions? Are we bound by other jurisdictions? Are we bound by NARUC manuals? I mean,
No, you
what-
have,
Yeah.
Pura has so much discretion. We learned that through the court cases. It's been validated on the factual findings. You are the fact finder. You judge the credibility of the witnesses. You're not bound. You can come in with a new standard on rate, case expense, and, you can do that. You have lots of discretion. What I'm trying to bring to you is, but it's somehow on the total here, when you look at the decisions, they're all going against the utilities. So I don't know how we're getting to 91%. How can it possibly be intuitively right that when you look at the draft decision and every single one is going against the utility, how can it come out to be 91% of what they asked for?
Yeah, well, it's actually higher. When the
I don't think-
calculate-
just
in the-
intuitively, that
Sure,
can't be
sure.
correct,
But the-
right?
Sorry.
Yeah.
The draft decision will include things that are disallowed. It doesn't go through line after line after line of the things that were accepted by the authority and are being granted to the company.
Okay, so that, I have heard that before. I've heard this before, and I'll use this analogy for that. You have a loaf of bread, right? And so you say, get half a loaf, right? We're getting half a loaf. So your thing is, you're saying you got all these things that aren't in the order. But the order is the contested issues, right? The order is the thing being decided by the fact finder. So that's all the contested issues. So what you're kind of saying is, it doesn't matter that you've lost every issue. You got half a loaf, you got everything else not in the order. But here, so all you've lost is the half a loaf that's in the
But
order.
Attorney Kimball, I apologize.
Yeah.
That suggests that you think our job here in this proceeding was to help you.
No, absolutely not. No way. I do not think that. We have to earn it. The companies have to earn it. They have the burden of proof. There is no obligation to decide one way or the other. But when you have tons of discretionary judgment, you just asked me, do I have to listen to precedent? Do I have to listen to rate making? Do I have to listen to the NARUC manual? No, you don't. But if you're exercising discretion and you're exercising it on a balanced basis, why wouldn't some things go one way, a different way? Some things.
A DIMP, ROE penalty.
That's missing the entire the picture. That's missing the entire picture of what this is actually doing. The ROE penalty is like $200,000 a year. Honestly, give me back the ROE penalty, because that was $200,000 a year. Now you've disallowed millions and millions of dollars of disallowance. Like, they're not co-equal.
We know that.
So
We actually know that. And again, those are two policy options that regulators have to address the issue of unused or
Absolutely.
underutilized mains.
but if the tie is going there, if that is going there, then why wouldn't, if this was truly going to be looking at, okay, we're going to try to use our discretion in a way that's balanced, then why wouldn't some of these come out for the utility and some not? And you're pointing to you're pointing to one doesn't even have anything to do with the rate increase, and one that's a very small tangential issue.
Okay, but DIMP is not insignificant. That's a pretty big number, actually. When we looked at your budget number, when I did, and we talked about it, I actually, for a minute, paused because this is a big number.
It is.
And it reduces regulatory lag, it accelerates, recovery, it's credit positive. So to me,
That's a
and
good thing.
it's
Yeah.
responsive to something we all agree on, which is
Yes.
pipeline safety. So, so that,
But the problem with it is when Pura cut it before, the program got cut. So you can't just you don't just snap your finger and build it back up. The company will build it back up now. It's a good thing. It's a good decision. Very much a good decision. But now you have a whole series of other things that have been decided from a policy perspective in a way that ends up being not always even good for customers and punitive in some respects
okay.
to the utility.
But you kind of indicate in other various parts of your exceptions, you kind of like the idea of a capital tracker, or, some kind of mechanism to allow expedited recovery. So isn't that kind of in that ballpark for you? I mean, so yeah, you wound down that program, but it's not something the company doesn't understand, and you obviously have experience with the DIMP program.
Yes.
DIMP.
But the jump only covers, I don't know off the top of my head, I think it's roughly 40% of the capital investment. It's not all of their capital investment. So yes, I love what you just said. I love that you picked up on, it is great. And I said Massachusetts uses trackers instead of rate year capital, but they're not co-equal.
But it's a substantial amount relative to your rate base, isn't it?
What
The
is?
DIMP allowance, the DIMP budget.
A substantial
I
amount.
mean, it's relevant. It's relevant when you think about your capital investments.
It's important, it's relevant. I'm not going to undermine that.
Okay.
No.
Okay, very good. I think we've talked about that. Okay. You do have something in your exceptions that I thought might have gotten lost in translation. At page 36 of your exceptions, if you want to take a look. It's kind of back on this used and useful question. I just want to say it out loud for clarity. So here's the actual quote from the order. The company also claims that the mains are used and useful because they are capitalized consistent with GAAP. Nonetheless, while the mains may meet the company's definition of used and useful for accounting purposes, they do not meet the used and useful standard for utility service. Now, maybe we can clarify the wording, but I think we've agreed in this hearing room various times that there's a difference between GAAP and regulatory accounting. And I think that was the message there. And I would say that it's not inaccurate.
I 100% agree with you. The used and useful is for gas companies, it's whether there's live gas in it.
Yeah.
That's it.
Okay.
Yeah.
And I do appreciate the honorable mention I got in your exceptions, but I would encourage you to, and actually ask you if you have testimony from somebody who's actually qualified to talk about the system benefits of energized pipes that are not actually connected up. Is there something in the record that I'm not aware of that demonstrates system benefits that would be to the benefit of ratepayers of, if I'm saying it correctly, of that energized pipeline that's not being
So just,
used
can I
by
just
repair?
make sure I'm answering the right
Sure,
question
sure.
there? So your question is, if I have a main and service and it's got gas in it and everything, it's all built, but I don't have a customer on the other meter.
Right.
How is that benefiting everybody else?
Yeah.
Okay, because the system operates as a whole. And so there's always going to be customers coming on and off. And so the test of what is used and useful is not whether it's benefiting customers at that moment in time. That is the prudence determination. That's what I'm concerned about. The prudence determination is there a benefit to customers of adding another customer here? And the benefit is figured out through that hurdle rate, which was approved. And the other thing I want to mention about the hurdle
I'm
rate.
sorry, the hurdle rate was approved by whom?
It was approved by Pura. It was approved by you in these decisions. It's in the
Okay,
draft
that-
decision.
you mean that, okay.
Approved the hurdle. One thing you should know that I forgot to mention before, in 2013, when the hurdle rate was developed and put together, there were allowances that were built in already to the hurdle rate for the potential for for those expectations about the customer coming have been built into the hurdle rate. Like it's worked, I could give you the site, it's a 2013 decision. And so the hurdle rate already encompasses some measure for customers to accommodate the fact that it may not always come to fruition the way it was built into this hurdle rate.
Okay,
Okay.
okay, thank you. Yeah, go ahead.
Somehow we got into hurdle rates, but did that answer your question? I thought your question was when you have a pipeline to a non-existing customer that's full of gas, is there something in the record that shows that that gas in that particular pipe is benefiting the balance of the system?
Exactly, that was
And
my
that I
question.
don't
Thank
think
you,
we answered.
Commissioner. Yeah.
Yes.
Do you have an answer to that? Is there a witness testimony I could refer back to?
I need to check for the witness. I don't have the exact site.
Okay, we'll be taking a break at lunch, so
Okay.
you can squeeze it in, I'm sure. So when you refer in your exceptions on page 44 to small portion of services not yet connected to meters, is that now, does that reference now or back in time when, you know, for the record evidence in this case?
So my understanding is, again, I can check this at lunch. So 99% of the new gas main that's been put in is connected to a current customer. There's this 1% that is not.
You mean now in 2026?
I believe so, yes.
Okay.
I can double check that.
So, okay, but remember, yeah, again, we're trying to abide by our rules of time travel. And
Do I have that right, or is that?
so,
Well, I'll double check that.
okay, okay. And then finally, on this set of issues, I think you noted the need for, if the rate-based disallowances are to be maintained, you're asking Pure to consider a bunch of technical corrections, is that correct? Technical changes to the order. I think this is at page 45 of your
Yes,
exceptions.
yes.
That we'd need to go back and take a look at that.
I just want to go back to that question for a minute about the benefit of customers. So I just want to be careful there, and I'll look at this at lunch, but this is a rate base is a prudence determination. There's no coming back afterwards to say, are customers benefiting from this part of the system or not, if it's part of a live system. So right?
We're talking about before it goes into rate base, though. We're talking about
The only thing that goes into rate
prudence,
base is a
business, and useful. I'll give you an analogy in water, and so
Okay.
take another moment, but I know a little bit more about that. In water, you actually, you want water circulating because it's something we consume, and so there are issues about stagnant water and so on. So there actually is some benefits of having water, even though they would be held to the same standards initially of use and useful and prudence. There's, gas doesn't quite work that way. And so, I'm still looking for. And
I guess
Commissioner
why
Smith's gonna help
do you
me.
think gas doesn't work that way?
Well, we
Yeah.
don't,
Because it has to maintain pressures, right? It has
Oh, yeah,
to
yeah,
maintain,
yeah.
okay.
And that's in the capacity of the system.
But I think if you have a pipeline system and you add a appendage over here, that's the new pipe, if you took that away, you're not going to lose pressure. You're just adding more pipe that, I think your question was, is there anything in the record that proves that that pipe is somehow benefiting the balance of the system?
Yes.
And then I think it further goes to the question you probably raised, that is building a pipe and putting gas in it enough to meet the level of use and useful? Or do you have to go that extra step and have a I think probably a single customer hooked to it?
Yeah.
Right?
Yeah, right. I was trying to parse the system benefits as compared to the use and useful test is pretty clear. If somebody's getting service and then they're sending you revenues, that's a clear relationship. But if it's just they didn't show up, now you've got the capacity and the gas. How is that helping other ratepayers who are picking up the tab because there's no revenue coming in from that
But that
connection?
happens all the time. That's part of a
In the
utility
future,
system.
I think we talked about this.
Yeah.
In the future, but I'm talking about in that initial investment that's been made that didn't pan out.
But that is the prudence determination is at the point you made the investment, there was a customer there. This is why I'm cautioning that we're getting used and useful mixed up with the prudence, because at the time the decision was made, that customer was there.
Well, there was a high probability of the
But
customer, but
there's
there
never
wasn't,
going
they
to
hadn't
be a-
given you an advance, for example. If they give you a customer advance, they probably would be, less reluctant to.
You have, the hurdle rate is what determines that. So they may have given a kayak, right? They may have given a kayak. So you're determining at that point that it makes sense to the system to bring that customer in because that customer would share the cost of the system once they got on. Their revenue would share the cost of the system because they're paying rates, so the costs get spread for all the customers, right?
Okay.
So at that customer is, you're making the prudence determination. So for to come along afterwards and say, no, you're losing recovery of it because that customer didn't show up, that's actually impermissible hindsight on the prudence. That is not used and useful.
Okay.
Okay.
All right. Couple last quick questions on board of director costs. When we say board of directors, are we talking about Avangrid, Iberdrola, companies? Who is this board?
So I leave you to those. I don't have the whole details in my head about which board, which expenses. I can look that up. My comment on those expenses, and I didn't go there here, the one that really bothers me is the audit expense because for each one of those issues, Pura has made a percent. 50% for you, 50%. It's prudent. So as soon as you say there's a percent, as soon as you say you get 35% or 50% or 65, you're saying that the cost is prudent. You're just saying that you're not going to be able to recover it all because we're going to say.
These are two separate determinations.
Right.
There's
Two
prudence
separate-
and then there's allocation between shareholders and
Agreed.
ratepayers.
Agreed.
And that requires a judgment call. And unfortunately, we don't always have the ideal metrics. Something we're thinking about, how we can inform those and how we can present to a judge, for example, our
Right.
rationale. We're working
And
on
Judge
that.
Medzig actually looked at this with the Aquarion remand
Yes.
on rate case expense. And what he said is, okay, you want to divide it, Pura can do that. And I 100% agree that that's right legally. But Pura has to give a rationale, a reasoned basis for how it's splitting it. I would say when you look at, for example, either board of directors, or that's maybe why you're asking, but really more so, I think that audit expense, the draft decision doesn't articulate, it makes some changes from the original decision for sure. That's one place where you're going to see some edits. But what it kind of did was just put in some more words for what discretion is. We have discretion. We've made this in our expertise and our judgment, like it put in like a whole bunch of more words that mean the same thing as discretion.
Right.
It never really talked about how are we getting to half and half
Yeah.
because, right?
But in rate making, you bear a burden, right? So in some ways, what these orders communicate is that we're struggling. We see an international board of directors. How do we know they care about Connecticut and Connecticut's ratepayers? We see a holding company structure. How do we fit there? And how are, we're asking Connecticut ratepayers to support these costs. And so we need to have some level of confidence that we're making a good decision, that we're making a fair
Right.
decision to them. So
I don't disagree with that at all. You're completely right on all of that. And I don't think that's I have not raised that today. That's not one of, I would say out of that kind of trio of expenses that are half disallowed, it's the audit one that I would want you to take a look at because audits are so important to the rate make, all the controls. We just see that and, any big documentation any utility is going to bring into you, that audit expense is 100% benefiting customers. This relationship to shareholders is so tangential as it's written here.
well, wouldn't the opportunity to earn a fair return depend on,
Well, then why not just cut
efficient-
everything in half,
efficient management?
right? Why not
Well,
cut
that-
everything in half?
Right. So I think,
Okay.
again, these are, yeah, go ahead.
I
No,
was
jump in.
myself. I was muttering.
Okay, he's muttering.
But since you turned to me, I just
Yeah.
said, I would like to beat this dead horse a little bit and say, if you could remind me where in the record, if any, it talks about how you define the board we're talking about here. I think if it's an internal board that only oversees the affairs of this company in Connecticut, that's entirely different than if it's the Avangrid board sitting in Spain overseeing a global energy empire. And I become less sympathetic the further we get away.
And so do I. So this is what I believe, and I can double check this. When Iberdrola came back in and bought these companies, there were settlements and there was a whole bunch of ring fencing that was put in, and there was requirements for boards, not inside the utility, but at a holding company level that was directly in charge of the utilities. So off the top of my head, I think there's 2 or 3 layers of boards. I can check this out. I believe this one is for the more immediate board that was actually required by the settlement in part of that ring fencing, but I can double check that.
Right, and then I would just add, in the future, do you think it would be helpful if somehow we got all the different people together and looked at these things that seem to come up over and over and over again in these cases and just come up with what the right allocation and policy should be, if that's possible, or do you not?
I mean, the utilities would love that, but hopefully that's what happens in a rate case, right? Is that that's why I'm urging, think about some of these impacts here on customers, on the utilities, because these are real rate-making policy issues. Usually public utility commissions do that in their orders. They articulate, everybody reads every order, everybody adheres. Utilities are so good when they have rules and policies and they have things that they can go by and order their businesses around. They're not so good when every single decision is just going in a different direction, because then it's like, what do we go and improve? Because we don't know, because every time it's different. So we are hoping as a utility community in Connecticut that through the orders, we will get to some more standardized rate-making policies that used to exist. And hopefully we can get back to that again.
Okay, just so a couple last questions on depreciation, just to drive home the point. There's a reference to the NARUC manual. It's a 30-year-old manual, and NARUC doesn't set standards.
Correct.
It's a guidance manual.
Yes.
You'd agree with that? And does that guidance allow for alternative methods?
It does, but it does, of course. I'm not going to say, and I have some level of familiarity having done cases over the years, but it also sets a standard. If you're going to just have people coming in that are just deviating every which way, I guess then some additional scrutiny needs to be applied, because that set of guidance is foundational.
Yeah, and by the way, I may be the one responsible for redlining the word systematic next to systematic and rational. So apologies for that. I think the reason I flagged it is because I was worried about some ambiguity. I wasn't thinking about it as a term of art. So
Okay.
My bad.
Point taken.
And but I also that caused me to go back, and your exceptions caused me to go back and think about it. And I think the reason why I was flagging it was because I was worried that it implied mechanized, and you raised the issue equal, and I'm not sure that that's necessarily a criteria for a rational. In other words, it may not be equal. It may be formulaic in a way that incorporates other factors. Would you agree?
Absolutely,
Okay.
yes.
So we'll just drop that right there. So again,
Yes, I completely agree.
can't blame anybody. I'm going to take the hit on that one. I'm going by by memory, but so I've been marking up a lot of things lately, as you might imagine. And then one last thing is the depreciation rate. Of course, depreciation expense is related to accumulated depreciation. That relates to the value of the rate base. That relates to return. So it does cut both ways, right? And so yes, you don't get that cash flow from the higher expense, but you do maintain a rate base longer for a return opportunity. Is that correct?
Yes, I don't think I would ever be talking to you today about depreciation expense. And it is one of the issues we had originally appealed. And I was literally like, I am sick in the head if I think I'm going to court on depreciation expense. But that was one thing we included. But the reason we did, because it was so drastic. It was just so drastic. Like, for instance, if I I actually had somebody prepare, go back and look at, a bunch of cases and look at what Pura had done, going back, 10 years or so, back to 2010. I don't think, so when companies come in a case, they come in with a depreciation study. And usually they're asking for an increase. So there's two kinds of increases that have to happen. You have to be careful when you look at it because depreciation rates can stay exactly the same and expense can go up because your rate base goes up. So your total expense on depreciation is going to go up even if you just keep the same rate. So utilities are usually coming in with a depreciation study. Usually they're looking to have some increase in the depreciation expense, forget about putting aside the rate base increase. Like they want depreciation to be increased. They want things to be depreciated more quickly, generally. And so but that, as you said earlier, that has rate impacts for customers. So that's normally the one thing every commission will cut is cut back on depreciation. But if you go back to 2010 in Connecticut, it's been cut. Like here, the company's only proposed like basically a 5%, just a small increase in depreciation, forgetting about rate base change, but a small increase. But it got cut by like half. So there's no other decision that you can point to in Connecticut in over 15 years, even in Aquarion, the terrible Aquarion reduction, it got cut out of like, $40 million, $2 or $3 million, right? So here you're cutting, I think it's CNG by like $20 million out of 50. So you're killing them, right? You're cutting the depreciation back so much they got a credit downgrade because of the cash flow that it cut off. And it's all because of that net salvage, which no one has ever added up. You cannot add those numbers up. So that's why they were in the original appeal. Good luck to anyone trying to explain that to a judge.
Thank you.
All right. I think this is probably a good time to break for lunch. And if you have nothing further at this point, Attorney Kimball?
The only thing thank you so much, Commissioner Cheeseman, for giving me, just one thing I wanted to note on the rate year capital. I would just urge to look at these court cases that are cited here. For instance, the first one that's cited, Cedar Island Improvement Association versus Connecticut Electric Light and Power Company. This has been cited by Pura over and over again in these draft decisions. And it cites it for the principle that inclusion of forecasted incomplete plant deviates from the fundamental principle that rate base should solely reflect prudently invested capital actively serving the public interest. If you go look at that case, it doesn't say that. It does not say that. That's not what that case stands for. Pura's used that over and over again. That case is from 1955. That case was about an extension of electric service, because of course in the old days there wasn't electric service everywhere. So you're trying to have policies that would promote extending electric service. And this was a dispute that the Public Utility Commission lost, that went to whether or not a Public Utility Commission could mandate, service to be extended. But in the course of that, what this case actually says is that it says that let me just find the exact quote. Okay. In regulating the activities of a public utility, the state is exercising its police power. The method and extent of the exercise of that power resides in the determination of the legislature. It cannot be exercised in an arbitrary and discriminatory fashion. If it is, the act is unconstitutional. We're not talking about that here. But here it says next, a public utility company is entitled to a fair return upon the fair value of its property that is used and useful and being providing service. So when we look at the rate year capital issue and we look at the actual legal precedent, it doesn't exactly say what the commission is citing it for, but it's coming from past orders. It's really saying that if you've got something that's used and useful for service for customers, you ought to be collecting it, which in this case is unique because it's coming after that rate year capital got put into service. So this actually argues for allowing that future rate year adjustment, because it says if it's used and useful, it should be in rates when you have the opportunity to put it in rates, which exists in this case, subject to that reconciliation mechanism. Okay, that's it.
All right. We will break for lunch. It is 12:34. We will return, we will recess for lunch and then return at 1:15. All right, welcome back. We will return to oral argument and turn to Office of Consumer Counsel, please. Attorney Minikowski and Counsel Coleman.
Thank you, Commissioner Cheeseman. Andrew Minikowski for the Office of Consumer Counsel. In general, as we stated in our written exceptions, the OCC takes no exception at this time to the proposed final decisions. However, I would like to address several of the points that we have discussed this morning, just to provide the OCC's perspective on those. The first involves really just a foundational issue, which is the remand itself. You know, the authority has issued its new proposed final decisions in this matter, and the other matter that we'll be addressing after this. It's important to recognize what the court did do and what the court did not do in that original appeal. And in that, those original appeals, they were decided at the threshold stage of those initial procedural issues. You know, Pura had gone into court with a motion conceding that there were certain legal errors in the appointment of the presiding officer, in the deciding of motions, and other preliminary procedural matters. However, the court never reached the merits of the actual rate order that was being appealed. So depreciation, for example, the court never evaluated depreciation and said Pura applied the standards wrong. There was no evidentiary basis for its decision or what have you, any of the 6 reasons the court could have overturned that. Instead, the court sent it back, but it never reached those actual, merits-based issues of was the rate order itself compliant with the prevailing law and standards of utility regulation. And so we've heard this morning some argument that, there are parts of the new proposed final decisions that are the same as the original final decisions that were appealed. But I think it's important for the commission to keep in mind that in all of the rulings that came out of those initial 2 administrative appeals, at no point did the court say the rate order itself is legally wrong as a matter of rate making and the law that governs that. It was really these procedural orders. I think it's fairly attenuated to say that because a motion for protective order was ruled on incorrectly, that somehow translates to a legal error with how the authority calculated depreciation rates, for example. So I just wanted to set the foundation for that and reinforce the standards of what had actually happened. And as the authority has recognized this morning, there are portions of the new proposed final decisions that do differ from the final decisions that were issued in the original case, and that's to be expected. There's a new panel of commissioners at this point. You all come to the case with different philosophies and different viewpoints, and it's likely that you would change your mind on some issues, but also perhaps follow a similar outcome to how Pura had approached those other issues in the past. The other issue I'd like to touch on is the prudence standard and the used and useful standard. We've discussed this a lot this morning. And Commissioner Beecher articulated it the same way I would have articulated it at one point this morning, which is you have that prudence determination where the authority should not be using hindsight judgment. And that's the threshold question. But then there's still that question of, okay, the decision was prudent or wasn't. But is the actual recovery, the asset that we're looking for recovery for, is it actually used and useful? Is it actually serving ratepayers? And that's a second part of the question. And that part is necessarily hindsight based. The prohibition on not looking into the past and saying, well, here's what you should have done, that applies to prudence, the reasonableness of the decision at the time it was made. But used and useful is necessarily a standard that requires any utility commission to look at what the thing is and what the thing is doing. And if a commission doesn't look at that, there's really no way to make that determination. If a gas main is serving customers or not, the authority has to look at that. And that is necessarily an inquiry that can require some hindsight-based analysis.
Is there any Supreme Court law on this particular question?
So, there's myriad cases on the used and useful standard, starting with Smith against Ames in 1889, the foundational case, which I'm sure I don't need to explain to you, Commissioner Beecher, where the used and useful standard was articulated. We have we have multiple cases in Connecticut that articulate the used and useful standard, but I actually think to this specific point we've been discussing this morning, it's actually some language that's in the Superior Court's decision from the December 2025 Aquarian Water Company appeal. And in that case, the court said, and I quote, This court holds that PURA may reject recovery of otherwise prudently incurred expenses if PURA concludes in its broad regulatory and rate-making discretion that consideration of the other statutory factors set forth in General Statute 1619E warrant that outcome, end quote. So the court there is saying there are situations where PURA may say, yeah, this decision that the company made was prudent, but looking at 1619E, the other factors in there militate against awarding recovery in that case. And one of those factors is that the decision in question serves the public purpose. And that gets to the heart of the used and useful standard. If a particular investment is not serving customers, it's not serving the public purpose of utility service. So I did just want to clarify that one point. We've talked about the rate year capital and the additions, and I had made this point at length in the earlier oral arguments that we had this year at some point. I have no memory of when that was, but I know they happened because I remember talking about this. But at the time, the OCC had raised the point of, we understand where the company's coming from, where PURA is relitigating a rate case from 2023, but it doesn't make sense to take one piece of the revenue requirement and use 2026 numbers and then use 2023 numbers from the rest of it. And I think, the authority had agreed with the OCC's objection at the time about letting new evidence into the record. And, the remedy for the company in this case, I know it's not a palatable one, but it's been there all along. The ability to file a new rate application with numbers that are completely up to date to the present, with a new test year that would allow for rates being set at the time. The company's written exceptions talk about how these rates are unjust and unreasonable. Again, a court never made that determination. And I would like to point out, the company has been operating under these rate orders for 2 years now. They were never stayed, and we have not seen the company declare bankruptcy or be unable to provide service to its customers or unable to maintain its system in that time. We've heard this morning how every decision, quote, goes against the company in these proposed final decisions. That's patently just not true. If every decision had gone against them, the rate applications in their entirety would have been rejected. As the authority mentioned, its decisions reflect the disallowances, those issues which are contested and adjudicated. There are a number of issues in any rate application, these and any other case, where the parties do not differ and the authority grants recovery. And that happened in this case as well. I would like to conclude finally by mentioning one point. We heard this morning how the OCC's written exceptions were brief, which means we're happy, and we took no exception to the proposed final decision. In preparing written exceptions, like any other pleading, it's a balancing. It's an active strategy. We look at a proposed final decision, and there may be things in there that we don't necessarily agree with, and there are in these proposed final decisions. But on the whole, we look at the proposed final decision and say, is this something that serves our mission of serving ratepayers? Is it something we think that is fair and is reasonable to them and does not have some sort of fatal legal error or problem in it? And in that case, we might not necessarily object. I think if the commissioners recall the oral arguments we had earlier this year, there were several issues, the ROE penalty, the DIMP cap and what that DIMP cap should be, that went in ways that we didn't argue for. And that's fine, because we look at the decision as a whole and say, all right, maybe we lost on this issue, but we won on this other issue, and it balances out, and we're not going to take exception to the proposed final decision under those circumstances. I think the authority knows what it looks like when we take exception to final decisions. But just because we say that we're not taking exception to a decision doesn't mean we're 100% satisfied for it. We just means it passes our internal threshold of, our mission has been served here. We think this decision strikes the right balance between allowing the company the revenues it needs to operate and providing ratepayers fair rates that they can pay and get the service that they should expect in return. So unless the commission has any other questions, or if Consumer Counsel Coleman has anything she'd like to add, I would conclude.
Thank you, Attorney Minikowski. I think that was all well said and captured all of our positions well. I think the one thing I would add is just an appeal to the authority to maintain and preserve the principles of, in one-year rate cases, not allowing for prospective plant in gas cases. I think that you've heard extensive arguments for reconciliations, instantaneous cost recovery beyond what is already in the decision, which is, the plant through the end of the test year, as well as the DIMP, which is already in place to allow for additional instantaneous cost recovery. Attorney Kimball talked about this being a tight or conservative framework that has negative implications on utility customers. And I'd submit that we are in an era where we need to be on tight conservative budgets and really looking at what are the essential needs for customers and for the company to allow for safe, reliable service. And there was extensive evidence that the balance struck in the decision is the right one, and that we all need to keep in mind affordability and cost containment mechanisms are important protections for customers that I hope you'll preserve. Thank you.
Thank you both. I just have a few follow-up questions. You anticipated one or two of my questions, so I appreciate that, and as will my colleagues. But can you offer any opinion on the standing of proposed final decisions here at Puro? And in this case, the one that we have in front of us now, or the one that back originally, like what is their legal meaning in Connecticut?
I always seem to end up getting quizzed on the UAPA when I'm up here. So you raise a good point, Commissioner Beecher, and I think the various parties, including SCG and CNG, had discussed this at the procedural meeting that the authority held several weeks ago. Technically, under the UAPA, a proposed final decision only needs to be issued in those cases where the commissioners on the panel, not all of them actually heard the matter. As a matter of practice, however, PURA has issued proposed final decisions as of course, just as part of its routine procedure in the vast majority of dockets. I'm hard pressed to think of a proceeding in my time before PURA where the authority has not issued a proposed final decision, whether it was legally warranted or not. And I made comments to this effect the other day, but I think it's of benefit to the process. Because of exchanges like those we've had today, where the parties can raise any concerns they may have. It also helps the authority. There are inadvertent mistakes that end up in decisions all the time. Math errors, an incorrect citation, a statement of law or fact that may not necessarily be reflected in the record. And the parties have the opportunity to flag that for PURA and give them time to go back and deliberate and consider whether that truly is an error or whether it does reflect the intent of the commission. At the end of the day, what matters legally is the final decision. That's the voice of the commission, sort of the consolidated voice of all the commissioners is the text of that final decision. But this case is one of those cases where, is a proposed final decision necessarily legally required? No, but I think it benefits all parties to have that opportunity to come in and provide that feedback. And I think the exchanges that follow the issuance of those proposed final decisions benefit the parties too, because it helps us see how our own arguments are received by PURA staff and the commissioners.
Thank you. In some respects, it's showing our work in progress, sharing our work, in the interest of transparency and as you say, getting that reaction. But we don't sign it, correct?
That's correct.
And there's language at the beginning. I think there's some sort of disclaimer down there that it is what it is. It's a draft.
Essentially. Yeah.
Okay, all right, very good. And then my last question was, do you believe that we have satisfied our obligation to the court in terms of hearing this case anew and producing this draft order as we did, as a, I'll use the term redlined, or the company might use the term corrected, not necessarily the way they had hoped, but that we reflected and deliberated and looked at the record and the evidence, and then now we've produced this order. Do you believe we have satisfied our assignment here?
I do believe that, and I think the thing to look at is actually less the court's decision, because if you recall, there was some debate among the parties about what Judge Budzik actually wanted the authority to do. There was a motion for clarification that was filed with the court, and the judge issued a brief order essentially giving Pura quite a bit of latitude in how it conducted these proceedings, saying any procedures that comply with applicable law may be followed. Now, the authority at that point had choices to make. I believe the choices it made were reasonable. Parties can disagree about that. But I think staying to the record as it was filed in the original case and the authority coming to the same decision, or not to the same decision, but coming to its own decision afterwards, satisfies the court's order there. Now, there's been some question this morning of, okay, well, some of the issues came out in the same way that the previous decision did. Now, could we crack open a thesaurus and do what Commissioner Smith indicated earlier today and change a bunch of words and adjectives and verbs? Yeah, but is that worth it? I don't think so. I think a court reviewing this will recognize the procedures that the authority employed, recognize that the new slate of commissioners did deliberate on these issues and came out with its own take on what the rate order should be. And to the extent that some of those parts of the rate order came out in the same way, I think those particular issues are justified by support in the record and applicable law and would have a strong chance of being upheld were they to be challenged.
Thank you. And that's it for me. And I just want to mention other parties are welcome to chime in on these same themes at your designated time.
All right, thank you very much.
Commissioners.
Attorney Minikowski and Counsel Coleman. Office of Education Outreach and Enforcement, please.
Thank you. So we usually joke at EOE in oral arguments that it's so lovely to be after OCC because we don't have to do much. and we tend to agree with a lot of what they say. And I do. However, I hope you give me a few minutes to sort of mimic or reiterate some of the ideas they posited. Originally, our intent when we were preparing for these oral arguments was for me to say good morning, or rather good afternoon, and just let the commissioners ask whatever questions they may have of us. But there was a lot of language today that gives me pause, and one of which was discussed or pointed out by OCC was everything went in the against the company's favor. And that simply is not true. EOE has argued for ROE reduction due to poor customer service. We did it in our brief. We did it again in our written exceptions, and the authority did not agree with us. And we looked at the language in this PFD and saw that it was similar to the language in the final decision, but never once did EOE contemplate that the authority didn't consider these issues. It's just that the authority continued to disagree with us. And that is a reasonable option. You are allowed to disagree with us. That's the point of these hearings. Of course, we would like you to agree with us and find that the poor customer service warrants an ROE reduction. But substantially similar language is not evidence enough of a lack of deliberation, and I would be concerned to think it is. And on a sort of secondary issue about the remand, once again, we agree with OCC, and I genuinely couldn't have said it better myself, but I do want to point to the language that was in that initial remand specifically, which is, lastly, the court addresses CNG and SCG's argument that despite the procedural errors outlined above, this court should still deny the motion for remand and go to decide CNG and SCG's claims of substantive error in the decision below. The court declines to take this action. They did. It is exactly what OCC said. There was never a finding that the underlying decision, any of the words specifically, were incorrect. It was simply on the procedural errors. And unless we have nothing further, unless you have any questions.
Just a quick one. So your proposed remedy to customer service issues you raise would be like a return on equity adjustment?
Yes. So there was one ordered in the UI rate case in 220808, I believe, that was appealed and upheld. The court found, and if you give me a second, I have it open, that there was enough evidence in the record to support such a reduction. The reason being, if you can see in our brief, there's been a lot of opportunities for the company to correct misinformation or different customer service procedures that lead to inaccurate information being provided to the customer. It is, as a regulated utility, their duty to serve the customers. And part of that duty is to ensure that they are provided the correct and accurate information to assist them. We understand that during this procedure back in 2023, there was a shift from their original vendor, ICOR, who had substantial issues, to Alorica. But we still found a lot of errors in these calls. And I think we joked that if EOE was so good at picking days where calls were wrong, we should go to Monte Carlo instead of being here. But we still, in SCG specifically, found 19% of the calls were incorrect. And I would like to stress it's not our opinion that the calls were incorrect. Our belief that they are incorrect is based on the responses that we asked in interrogatories, because we allowed the company the opportunity to tell us we were wrong. We asked our questions. We heard this in the call. Was that correct way to do things, or was that the incorrect way to do things? And we were told time and time again, and in SCG, it was 48 of the calls were incorrect. That's not our word. That's not my opinion. That is what the company said. And I don't think that's personally acceptable for that error rate.
Okay, thank you. And does Pura at this time have a well-defined framework for translating service quality issues of any kind into a return on equity penalty? Like, do we have a system, or actually on the flip side, or a incentive mechanism? Like, do we have an established enough framework to be implementing what you're suggesting?
So I'm going to take your question as more of like, are there metrics? Are there set metrics? I would say, are there set metrics as in a PBR metric? Not yet, but are there set orders that the company is required to follow? And did we make all of these programs as automatic as possible so it's almost failure proof, and yet there are still failures? Yes, we did. So to the extent that there are orders that are not being followed, and despite, and I can find it real quick if you want, the litany of other dockets where this issue continued, the company still has not corrected that issue, or did not in the evidence correct that issue. And I think that is enough of a metric to make this decision. It is EOE's opinion that we've tried and tried and tried, and if there are still errors, then you got to change something. You have to incentivize better customer service and more of a robust audit system of it. And the only way to really do that is an ROE reduction.
So I agree that the metrics on the performance side, the service quality side, are relatively straightforward, but you could certainly explore a lot of options there. But connecting that to an actual numeric ROE adjustment is a different step. And so you can respond to that, but also then, if the authority is going to contemplate that, should they be alerting customers on a forward basis, and actually maybe even saying there's a range of return adjustments that we might consider relative to service quality improvement, or or failure?
So to your first question, I think that goes into the discretion. It is the authority's discretion to use the tools that it has to ensure that their orders are being followed. That is what was upheld in the Avangrid appeal. The court concluded that Pura adequately stated its reasoning for determining that they had poor customer service, and that those reasons supported Pura's reasonable factual conclusions and substantial evidence in the record. That was on an ROE reduction. And as far as the notice, they were on notice. This happened in UI's rate case. And before that, there were NOVs for poor customer service. There was plenty of notice that customer service was an issue.
Okay. But would you suggest, though, that maybe we could be more explicit, more direct? And you mentioned PBR. A PBR framework might facilitate that. Do Do you have thoughts on that?
So I will still say, I do believe we were very clear. However, I do not think your point is an unfounded one. I think that everyone benefits from clarity and rules and metrics, as long as we understand that sometimes we might set this metric and we find out it's a bad one and we have to change it going forward. And also, as long as everyone understands that just because the metric is there, if you still do something that's incorrect, you are not excused from that incorrect behavior. So with clarity, yes, metrics are always helpful.
Okay, one last question. So in establishing the return on equity, there's a lot of modeling that goes into that, and we get witnesses who have their models and come up with different ranges. You have yours, and so on. Is it also plausible that regulators would look at that range of possible returns and consider context, including performance across various metrics, including customer service?
I do think that's reasonable, and that's in fact what EOE argued. We had our own ROE expert, and we said that it should be at the lower side. We made a recommendation, but due to certain customer service issues, that the ROE that should be granted was on our lower side of our range. In the previous UI docket, we made the same argument, and the authority determined to just do a 20 basis point penalty.
Okay.
But I think it's perfectly reasonable to look at the array of experts' standard views, right? The ranges, thank you, that's the word I was looking for. And then say, well, because of all this evidence, yes, this might be reasonable, but we actually should grant one on a lower ROE, on the lower end of the range. And in the one to the company's benefit, I would say they also should be given an ability to get back up to whatever was determined to be reasonable.
Okay, so that might argue for some combination of a return plus a incentive, a separate incentive one, to allow for reaching for that additional return. But you need to look at it holistically, wouldn't you agree? Like,
Yes, I would.
yeah, because you can't have a penalty mechanism and consideration doubling up on the company. You'd agree with that?
I would agree with that.
Okay. All right, that's it for me. Thank you.
I appreciate Attorney Spanik. Although we were not asked, I would like to also comment, we similarly believe that you met the duties and requirements of what the remand decision was in this decision.
Thank you. Office of the Attorney General.
Thank you. Try and keep my distance from that. I'm not as used to it. I'd like to echo the comments of the Consumer Council and EOE, and we doubly benefit by virtue of them going first to take care of all the harder questions. And I also do want to continue the discussion on the fact that we didn't file exceptions in this case, or took no exceptions, is not necessarily a judgment that everything went 100% our way in a way that is never in any other case. That's not true. We like the Consumer Council said, we think it was a fair and balanced decision, and that's good enough for us because it doesn't always mean that the consumer advocates have to have everything that they wanted. I think it's clear the Attorney General doesn't usually spend his time just throwing flowers at the regulators and the other parties, but so we take that seriously, not to complain about something if it reflects a balanced decision-making on the part of the decider. I'll try and be very brief. I think I just wanted to address a number of the larger claims, maybe the process envelopment claims that the company raised from the beginning, that the entire record is poisoned, that the fact that large sections of the brief came to the same conclusions, the proposed final decision came to the same conclusions, it's evidence of something untoward, that you couldn't possibly go back to the original record and come up with new conclusions because the underlying proceeding was so tainted as to be unreliable for you to go forward. These are arguments that can't be refuted. They're in a way like not science. They're just statements. It would be an impossible task for you to go back to the original record and not be burdened by some of the stuff that was put in the original. But I think, as Commissioner Smith mentioned, all of this really elevates form over substance. And if the company really wanted to have a brand new decision, they can file a new rate case, and they can immediately if they want to. But it was the appropriate decision and it was referred to the PURA from the court to go back on the record as it existed. And I think you've done that. We heard a lot today that every single decision went against the company. I think both Consumer Counsel and EOE have addressed that. What does that mean even for the regulator to do? There's an application that is aspirational, I think, is a fair way to put it. When the company puts in their application, they ask for a lot. They ask for more than they know they're going to get. By definition, any decision, proposed final decision, is going to be somewhat less than that. And I don't think that's a trade secret. But it's not something to say that every single decision went against us. It's more like the process of a rate case is always going to be that way, and you're never going to get 100% of what they want. And even if it was only one thing, the ROE didn't go their way as to the extent they wanted to, it would still be a decision against them, 100% decision, even if they got everything else. I just wanted to go through my notes, and that is, I think Commissioner Beecher asked a direct question: is a correction to the proposed final decision necessarily mean a rate increase? And from the company's mind, yes, it does. And they answered that fairly. But again, that's only because the company's presupposition is that they should get 100% of what they're asking for. And that any disagreement with that 100% figure is almost an abuse of discretion on the PURA's side. And that's just not the way that this works. That the decisions were similar, that they were in the same ballpark, that they weren't identical, but the company would have you believe that's simply evidence of some kind of underlying conspiracy or underlying problem in the process, but it's not. It's just, in my mind, it says that the underlying decisions were fundamentally sound. And it was good that you tinkered around the edges, that you looked at everything again, and were confident that the decision at the end of all this process you came forward was the best you could make and was a fair decision. It may not be perfect, not everybody is going to agree with it, but it was a fair decision and it will work. The two questions that Commissioner Beecher asked on the standing of the proposed final decision, we agree it's not always necessary, but we think it helps the process. And there's value in that. There's value in the company knowing that they came 3 times, as many times as they needed, to be able to give you the information you need to make the best decision. You may agree with them, you may not. The same for us. We want to be able to come back and tell you again what we think would work. The proposed final decision may not be necessary, but it makes everybody go away feeling like they at least had another shot, unless, of course, the commission was biased, in which case no decision you render is going to be satisfying to the parties. And did you satisfy your obligation to the court? And I would say yes, as much as it's possible to do so. You were using the existing record, like the court said, and you came up with a new decision. It was not identical. It was similar. Again, we would say that's evidence of that the decision was fundamentally correct when you first made it. And whether it was improved, whatever, the process was done so that the end result is fair to both customers and the company. I didn't have anything else I cared to say, but if you have any questions, I'd be happy to answer.
No, thank you very much, Attorney Wright. Company wish to provide rebuttal?
Very nice statements, and I appreciate everything they said. I do think on the customer service side, that was one area of the original case that we had a lot of issues with on rulings, evidentiary rulings, so I just caution there, but I don't want to go back into it. Very well delivered. So I have some information just to answer from earlier today. If we could look at that chart again, the chart at the beginning of the order. So just to go through a couple numbers, because I think what was stated earlier is that the companies were getting.
Sorry, you're referring to table 1
Yes.
in those final decisions?
you, Commi-
Okay.
Thank you, Commissioner.
And we will refer to SCG
SCG,
to keep us in the appropriate
sure.
argument?
Thank you
If we
for
could,
making me do that. Thank you.
thank you.
Okay. If we look at that table, so the table is just, we have to look at how it's set up. So the numbers on the left side and the right side, so if we look down to the revenue requirement line where where it was pointed out 479 million versus 457. And I think if I remember right, we got to 90-something% by figuring out what proportion 457 was of 479, correct? Okay, so those numbers include gas costs, and those are total revenue numbers. Now, gas costs are on both sides, so if you take them out, both numbers go down. But that differential doesn't represent what the company asked for or got. Because, so the number you have to pay attention to, if we're trying to figure that out as a percentage, is the very last line. The very last line says that the revenue increase for SCG that was asked for was a $43 million increase. So in other words, when you start, it's the 479 minus 436. So we were asking for 43 million. So you have to compare the 43 million to the 21 that the company got. And when you do that, that's 49%. Okay, because the number up above doesn't represent either what the company asked for, the 479 versus 457. That you have to look at the 43 versus the 21, and that's 49%. And if you, so after this decision, what SCG is getting is 49% of what it originally asked for, not in the 90% range.
49% of the increase
Yes.
they asked for.
Very important, because when a company comes in with its total revenues, it's calculating a revenue deficiency. This a little bit goes to the good question Commissioner Cheeseman asked. So you come in, you're putting your existing revenues on the table, and you're saying my existing revenues are not enough. I have a revenue deficiency, so I'm looking for an increase to total revenues. So that is what the 43 million represents for SCG. That was the total revenue increase that SCG was asking for. It had 456, it was asking for 479. And it got 21. So it got 49% of the deficiency that it was asking for. And when we think about a rate order, when we think about the things we got that are in the order or not in the order, the rate order is deciding the deficiency, right? It's saying, we come in and we say our deficiency is 43 million. We'd like an increase of 43 million. Do not disagree one iota with Attorney Wright that, it is aspirational in some respects, right? It's the time, and I don't think anybody would disagree with this, it's the time for the utility to come in, put it in front of the regulator for adjudication. So does that mean you're coming out? I don't think any utility thinks they're coming out with 91% ever, right? That I've never seen it happen, even in small water companies. So really SCG right now, after this decision, is getting 49% of what it asked for. So that may sound like half and half, but we have to look at what is comprising that and what's been left out. So conversely, and we're not on the record for the other company, but when we are on the record for the other company, if you look at the same table, you're going to calculate that CNG got minus 102% of what it asked, because it asked for a $20 million rate increase, and it got now, with this decision, it has draft decision, it has a $20 million reduction. So it's getting it's lost 102% of what it asked for. And so, maybe when we go back, that would counsel for looking a little closer at the decisions that were made for CNG. Because part of that is going to be that very onerous depreciation. It's going to be the FCIC, very small. Think about the difference here of $146,000. Doesn't change the dial here, but it means a lot to the company because there's bigger dollars behind it. So when we think about the things that we're raising today, which are the unused means, and I have a little more on that, which are those, the FCIC, the inflation, and the rate year capital, I will mention that of that amount, of the rate year capital amount, there are some DIMP dollars in there. So Commissioner Beecher, you were right about that. For that year of rate, for the rate year, there's about 4 months, it sounds like, of, and so that if that were to ever be considered, that would have to be, that could be deducted. But also, DIMP represents only about half of the total capital plan for the company. So I just wanted to say that. The other thing I wanted to say is, in the section on rate base, in the orders, I'll look at the SCG order. If we look at the standard, the legal standard for rate base, it talks about used and useful. It's a bedrock principle of utility regulation. I think we all agree with that. It does say that it says whether utility property is used or useful for inclusion in rate base is a factual determination. It cites to a case, Southern New England Telephone. But if we look at Southern New England Telephone and look at what the case actually says, it says property or equipment provided or acquired in anticipation of reasonable future need should be allowed as part of the rate base, even though wholly or partially unused at the time to which the inquiry of rates relates. So even the site that we're using here says it's a factual determination. So it is up to PURA to decide if that use of those facilities is near, that it be considered used and useful. And I think we're asking you, in the final decision, we're asking PURA to bring the companies up by just making a few allowances, to bring the companies up from getting minus 102% of what they asked for and 49% to just bring it up a little bit. And the reason I think that even the 49% is a little low, we know this because the companies got downgraded after the original decisions, and you can look, it's on file. They have earned well below their authorized return with these rates, current rates in effect. So they're nowhere close to getting to be able to get their cost of service, including the reasonable rate of authorized return. So I will just address one last point, then we can let everybody go unless somebody is on the unused means and services. So again, the standard is whether it was prudently, whether the costs were prudently incurred, whether it's used and useful. It is, and so the industry standard for is either it's part of the system or it's not. If it's not, it's abandoned. And so if it's got gas in it, if it's part of the system, then it is benefiting customers as part of the system. Because otherwise you could sit here, I love the question that says, well, what if you took this, you still could operate the system, but we could say that all the way down for some period of time. There's always, that's not the standard. I'm just asking to apply the actual legal standard. So the other thing you asked about evidence, there is evidence in the record that showed, because these are revenue producing investments, as Commissioner Beecher asked, when they're revenue producing, when they have a hurdle rate, some investments come in under the hurdle rate, meaning after you get done with the costs, you might have come in under your projected hurdle rate, but some come in over. And so the question becomes, how is the company dealing with its mains and services addition overall? Is it handling those, in a responsible, efficient manner? And what the record does show, and we have this evidence, which was put in RRU 369 for SCG and RRU 356 for CNG. And it showed that for both companies, the new growth that they've brought on is paying more than itself by about $20 million a year, both of them about 19 million. So they've brought on new customers that are adding a net benefit to the system of $19 million. That means that new growth is reducing the cost of everybody else because there's a net gain of 19 million over the cost to bring those customers on.
And when was that period that you're just referring to?
Yes, I can show you right. It says, this is the 2023 and 2022 is what we provided numbers on in these attachments.
Okay.
Okay, so thank you. All system all new customers since 2014 through 2023. So the cumulative, it's a cumulative number, 19. So, but the point is, again, going back, when the company, it's that hurdle rate that really matters, because when the company is making the go, no-go decision, should we do this or not, that's the prudence determination. They're saying there's an expectation of a customer on the other side. If that customer comes in, the customer is going to pay for itself. This is showing that customers have come in and not on the aggregate have offered more to the system. This answer also said, I think there was a question about the percent. And this answer to RRU 42 said that based on information in the docket, 1.9% of CNG contracts and 2.9% of SCG contracts were associated with the mains and the services that we're talking about. So it's a small amount, part of the overall program that has benefited customers in a net positive position. And the system is on, it's working. That person comes on and put the meter on, it's all ready for them. And they're going to come on and they're going to add additional net benefit to the system. So there is just no reason here that this should not be going into the cost of service, and there should be a deduction here.
And thank you. And that assessment of benefit is based on the revenues coming in from those.
So yes, thank you. So that would be, if every customer just came in at their hurdle rate, then it would be no, right? Everybody's come in at just enough, they're bringing in enough revenues to pay the costs of putting them on. This is saying that for the aggregate from 2014 of bringing new customers, the aggregate was a positive. So they've essentially reduced everybody else's rates in the end by $19 million. Because they're covering $19 million of costs with their revenues.
But these are customers who were actually hooked up and taking gas service, correct?
It is, but the costs, but that's counting the costs of the program, including those.
Oh, I see that, but it sort of seems to me like comparing apples to oranges.
I see what you're saying, but you're talking about growing the system. So you're trying to always look at what's the cost of bringing new load on the system versus what's the revenue they're going to bring on. And this is saying that in the aggregate, this program has brought in more revenue than the cost. So that's a benefit to everybody else. And this is like, this is just a point in time where there's not a customer on the other end because the customer didn't show up. But the decision to make that investment and put that main in was prudent at the time because there was a customer at the time the decision was made. They can't unmake the decision now, right?
I don't think, in my mind, there's an argument about that. But your counter argument that on the whole, everybody is benefiting because in effect, the people hooked up to service are paying more than we estimated they were going to pay does not necessarily translate to, well, then it's worthwhile to put some pipes in that nobody ever hooks up to because it all comes out in the wash and we're going to be better off anyway. I think you're trying to conflate two issues that in my mind you can't.
I don't disagree with that, the way you put it, but I guess where's the evidence that nobody ever hooks up to? If it's abandoned, it should not be here, right? Right? If it's abandoned because nobody's ever come, but that's not where we are with this. That's not the record is not showing that there's evidence that nobody's ever coming.
But it just occurs to me that there might be people who are going to come, but we don't know now, so give us the money anyway. And
Yeah.
we are obviously looking at this from different perspectives,
Yeah,
but
no,
that's
I
how,
don't disagree.
that's
with
how
what-
I'm
I understand what you're
seeing it.
saying.
All right.
Yes.
Thank
Okay,
you.
so I won't belabor it, but thank you for saying it that way. Okay, that's it.
all right.
Well,
Oh, do you
yeah,
have?
Yeah. So,
Uh,
so it's kind of almost like a stranded new investment in a way.
I guess if that's how you want to look at it, it is, except it is live. So it's part of the gas system.
But in the course of utility economics, there's situations where unfortunately, things just didn't work out or demand profiles changed, usage changed, and the utilities may have been caught with more or less capacity. And so in other words, sort of depending on you to make those good managerial decisions, but the reason you'll make those is because you bear some risk. And because if you knew you could always come to the authority for relief for every decision, whether it's this decision or others, you mentioned, that just trying to seek that, trying to address a decision. I mean, then it really becomes a risk-free enterprise, doesn't it?
There is no utility that is operating as a risk-free enterprise, especially over collection of customer services, like, but I don't disagree with how you're laying it out or how Commissioner Cheeseman is laying it out, but I go back to the legal standard. The legal standard is prudence, is you're making the decision at the time it was made, the customer was there. And what you're really doing by coming along after the fact and saying that customer didn't materialize, and so now we're waiting for a customer, is you're really saying that the original, and you're finding it to be essentially imprudent because you're disallowing it. And so you're really coming back after the fact to say the customer didn't materialize that you thought was going to happen. So that's a legal standard that applies to utilities. So, and I guess that's where I get hung up. I don't disagree with what you're saying at all. I can see that line of thinking, but I would think very differently if the service was lying there and it did not have gas in it, like it wasn't part of they never gasified. I would be totally agreeing with you, like it's not being used. But you're defining use by whether or not the customer's meter is hooked up to it, as opposed to whether it's a live part of the system.
Okay, so one case I didn't hear today, Mr. Minikowski, is Duquesne Light, the Duquesne Light. I don't remember dates, 1989, something like that. I had it a minute ago.
That was like a disallowance of a major nuclear facility.
That's a use
Yeah.
loss. Well, but this is the Supreme Court.
Yes.
So this is, for those of us who kind of just think up here, but the bigger picture, that's the one where they really established the idea of benefit to the public, right? That's what's attached to that, that terminology of used and useful that.
Yeah, so I'm so sorry. I remember it was about a nuclear facility, but I forget why. Did that nuclear facility come online or not at all or?
Pennsylvania, yeah.
I forget. But here, like you're talking about the distribution system, like there's no part of these mains or services that is like that wasn't a case, I don't think, where it was running. But I could be wrong because I can't remember all the details. I thought they kind of disallowed my recollection is they disallowed part of something that didn't come to fruition, but.
I think just more broadly, disregarding the details of the type of investment, was more to the rate-making principle. And again, sort of parsing prudence from from usefulness. So I just wanted to throw that out there.
Understood.
So I want to go back, I don't disagree with your point that you can I looked at aggregate revenue requirement, percentage of aggregate revenue requirement, because that's how we set rates, right? You come in with a rate application, you say, this is what we need to run this company and have a reasonable opportunity to earn a fair return. And you gave us that number, and then we, work through the case and the numbers, and then we come up with something. You looked at it at the margin, you looked at it at what you felt had changed. Keeping in mind that as we look at it, we're looking at the big picture. So we're looking at some things going up and down, and we're, you know what I mean? We're looking at that totality. So those are both legitimate ways of thinking about it. But when we step back and think about how we set rates, we are incorporating, again, that reasonable opportunity to earn a fair return, which is set, in the case. We are incorporating that into our decision, and we are cognizant of providing that. So, I think your numbers show a worst case scenario, mine show a better case scenario.
Except that the proof in the pudding is there was a credit downgrades, and then there was the rate of return that they're earning. So when the rate of return is half what's authorized, it means that rates are not collecting the level of costs that would be needed in rates in order to earn the return. Now, I'm a huge believer, no utility should ever expect to earn that return, like unless they're super good at like efficiency. Like that to me is the indicator of a utility is how they're doing against that ROE, because that a utility that has a poor ROE or a declining ROE will stretch. They'll find ways to make that better, and that's what a regulator should want. But the problem becomes when you get down to like 5%, 4%, which is where these companies are in actuality.
But just Attorney Kibble, I don't think any of this is actually in the record as it stands. Am I correct?
About the ROE,
Yes.
um,
I just want to make sure.
Referring to current.
Current, yes. Just want to make sure we're sticking to what's actually in the evidentiary record in these dockets in our discussions. So if you can just please bear that in mind.
okay.
Just pick it up from here. I agree. I think we see this similarly. We want the return to be something utilities have to reach for. But you just mentioned a second ago that they're getting insufficient revenues. Well, they could also have, what's the other side of revenues is costs. They may not be finding efficiencies or seeking cost savings. So it's the combination, right? That's what leads to the income deficiency, which leads us to a rate case to solve a revenue deficiency.
But
right?
when the revenues are so insufficient, there is a limit to how much efficiency can make up the gap. And when the ROEs are where they are, it indicates that rates is not collecting the costs.
Okay, so as Commissioner Cheeseman pointed out, we really can't contemplate post-decision events and circumstances. So we have to be cautious about that. However, in the exceptions, you mentioned, I think you mentioned credit somewhere. Did you mention credit and capital financing? You mentioned broadly. You mentioned, for example, depreciation or DIMP, how they affect that. And it just strikes me that a lot of this case seems to be about cash flow. It seems to be, which is understandable, because, right? I mean, because every entity, organizations, thrive on cash flow. And so I think some of your disappointment goes to the decisions that, depreciation being maybe the leading one, that affect that. But in this record, in this case, you would also have to connect the dots between these cash flow issues and and your capital financing and costs. And I'm not sure I'm totally seeing it. And so maybe you could speak to that a little bit. And my question is partly stems from the fact that it's a privately held company. So is the capital how does that sort of color the capital financing picture for you? And I know I'm not being really clear about this. So I'm trying to connect these dots between, the cash flow implications of the order, credit, capital attraction, quote unquote, and again, in that privately held corporate.
Definitely there was cash flow, issues here. I know that, the company was very concerned because the credits went back so fast, like instead of over 5 years or 7 years, or 3 years. So that's
The credits back to ratepayers.
right. Not that they absolutely should go back, but when you put something back that quickly, okay, good for customers, huge deduction, huge big rate increase, but those rates are coming back up in the future. And now they're going to come up by a chunk because the credit went back so fast, but also you're now having to put cash out the door that is very significant in the whole thing. But also it was the depreciation is very, but also a big part of it was at that point was because over half the rating is regulatory environment. At that point, it was this very significant uncertainty of being able to have a stable cost recovery. And that's the great unknown with credit ratings in my experience is that it's so hard as an attorney to demonstrate in a rate case because nobody can tell what a rating agency is going to do. They look at a whole bunch of things around the rate, and in a rate case, utilities usually put in like the rating agency methodology, and you can take a look at that, and I'm sure that's in this case. So I won't. Yes. So a big piece of it is how they judge the stability and the predictability of the cost recovery and a utility's ability to earn its authorized return. And so that's the great unknown that no one ever really knows. And that's the thing that says we're trying to find balance, because if we can find balance, you asked me several times, I do not expect that just because they didn't get what they wanted, that's why we're here. But it's trying to get to a sufficient balance that for two reasons, that the business can run without another rate case, right, for some period of time and have some stability. And also so that the external world, including investors and capital, the credit rating, which the utilities here they're rated, they're specifically rated. So it has nothing to do with so you're trying to show to the credit rating agencies that there is stability, predictability, and a level of adequacy, timely and adequate recovery. That's what the methodologies talk about. So that's why, that's what a utility is going to be fighting for in these situations, is to just get to some type of middle ground, totally taking into consideration what Attorney Wright says. It is not what they asked for. It is not. But it is probably more than half, because when you start getting below half, you're really digging into meat and you're really causing them into muscle, and you're really causing them to not be able to run the business and have to come back.
Okay, thank you. So mechanisms like DIMP and revenue decoupling would be viewed generally as credit positive, right?
I think that they are, yes.
Okay, how about litigation? How do credit raters view litigation?
Do you mean in
terms of looking at regulated utilities and ongoing litigation, is that something that they would consider?
I don't want, because I just said like it's all I don't want to speak for, but my experience is that they look at the rate orders. If the rate orders need to be appealed because there's some issues with it, they will expect the utilities to try to appeal, right? Because they, like everybody else, people who are going to lend or invest money in a utility, they're looking for stability, they're looking for lawful adherence to process. They're looking for transparency. They're looking at things years out. So they're looking for that stability quotient is really important. So because they want to be able to count on it. Investors and lenders, they want to be able to count on it. So when you see rate orders that are like all over the place or are not making decisions that are consistent with general rate-making policy, that's where they're going to be more concerned. Now, if there's litigation about that, I don't think they get, I've never heard of anything being like about the litigation. They're focused on those regulatory decisions.
Yeah, so, and we probably ventured a little bit out of the record here, but there is some in the record about credit. I think it's raised a couple of times. And so I just wanted to kind of, again, put that in the broader context and also not to conflate what shareholders might want or expect versus what credit rating agencies might look at there. There might be some differences there, some.
Yeah, I mean, that might be a little too far, but I know in this case we put a lot of information in about the credit because we knew that there was going to be a credit. At that point, when that case got filed in 23 after the Aquarion, like the companies knew downgrades were coming. So we did try to put a lot of, whatever evidence we had, we put in evidence about, how it was affecting the company. And so I think there's evidence about all the credit rating stuff in there because we knew if the decisions came out as bad as they could, given the situation, that there would be downgrades, and that is what happened.
Okay, thank you.
So Commissioner Cheeseman will kill me because I want to go backwards, rewind a little bit. You made just two.
I'm afraid of her too, so that's okay.
You just said two things. I want to make sure I have them right. For going back to the unused mains and services. So one thing I think you said was something along the lines of if you went back to 2014 to 2023 and in the aggregate, including the unused as well as the used, you were 19, I think, million over the hurdle rate. So you were plus 19, taken in its totality, right?
Mhm.
Okay, and the second thing you said was that if you look, and I don't know what time period, but if you look at the total mains and services you put in, the unused portion in question was 1.9% and 2.9% for the
I'm
two
just
companies.
reading, out of the discovery request that I had. Sorry, what did I say? RRU 42? Okay. Oh,
I should have these all memorized, sorry.
Yes, I'm just reading what it says in part B of that question. It comes out of that answer, yes.
Okay, so those are the two things you're saying in the defense of management.
Yes,
Okay.
yes, thank you for checking.
Thank you.
Okay, have I exhausted?
All right, so that concludes the oral arguments for 251113. We will now move on to oral arguments for 251114. First of all, is there unique information you would like to address in that docket?
No, there is not.
Would you like to adopt the questions and answers you gave with regard to 251113 to be applied to 251114?
We would, thank you.
Thank you. OCC, do you have unique oral argument for docket number 251114?
I do, Commissioner.
Well then, please proceed.
Well, I would like to address the United States Supreme Court's decision in Duquesne Light Company against Mirage.
Oh, except I thought Pura did ban the use of research in I'm not saying I do, but
Wasn't aware of that.
yes, that was a ruling in this case, as a matter of fact, that you can't look at your, one of the underlying rulings was you cannot look at your laptop and research during a case. It's in one of those motion rulings, but go ahead.
Is that for witnesses or for attorneys?
Well, it said for witnesses.
For witnesses.
Yeah,
Yeah.
go ahead. I'm just teasing, I'm trying to make a joke, not a good one. Go ahead.
So anyway, so I was familiar with this case, but I didn't remember it because these all blend together after a while. But what's interesting about Duquesne is it does involve the used and useful standard, but there is a temporal element in there, which the Supreme Court recognized in affirming the Supreme Court of Pennsylvania's decision to disallow the inclusion of a generating facility into an electric company's rate base. And it articulated it as such. It shall not be made part of the rate base or otherwise included in the rates charged by the electric utility until such time as the facility is used and useful in service to the public. And then the Supreme Court expounds upon that in a footnote, as they are wont to do. Justice Rehnquist was inordinately fond of footnotes. And they expounded that there that it is presently providing actual utility service to customers. So I think that does touch on something we've been discussing here today in this endless debate over the gas main with gas in it that doesn't have a customer at the end of it. At the time Pura looks at it, is it providing service to a customer? And I think it answers that question of at what point in time should Pura be looking at the used and useful standard? And it's the present. Thank you. That's the only thing I had to add. Otherwise, we would incorporate by reference the previous remarks we'd made this morning.
All right, thank you. Does EOE have any unique oral argument for docket number 251114?
Only that we refer to two numbers for SCG regarding the calls we reviewed and the percentage of incorrect / the omitted amount of calls that were incorrect. And for CNG, it was a 16% error, and it was 36 calls that they admitted to being incorrect on.
All right, otherwise you'd like to adopt the same
Yes,
oral
please.
argument for 251113.
Yes.
Office of the Attorney General, do you have unique questions with regard to docket number 251114? Or argument? Would you like to adopt the argument you supplied for 251113 for this record?
Yeah.
Thank you. Does the company have rebuttal to the one comment argument from Office of Consumer Counsel?
Okay, is this on? Can you hear me? Okay.
Yes.
It's been pointed out to me, so I'm just going to put it on the record, that this case also says a state's decision to arbitrarily switch back and forth between methodologies in a way that required investors to bear the risk of bad investments at some times while denying them the benefit of good investments at others would raise serious constitutional questions. And I'm not saying that's what we're talking about, but I did read it into the record. Thank you. That's my rebuttal.
All right.
Thank you.
Do commissioners have any last comments? All right. Well, I think that will conclude our oral arguments for today. Are there any procedural or administrative matters anyone would like to address?
But thank you so very much. Thank you for today. Thanks.
All right. Thank you. Office of Consumer Counsel, any administrative matters? EOE? Office of the Attorney General? All right. Well, thank you all for participating. I hope we've all found it illuminating and interesting and informative. I want to thank everyone for their rational arguments. And I think hopefully a collegial manner. And I hope we can proceed in all our dockets in such a manner. With that, that will conclude. The authority is tentatively scheduled to issue a final decision on September 16th, 2026, and we are adjourned.
Thank you very much.